Good morning. This is the Colorado Energy and Carbon Management Commission. It is August 6th. It's 9 a.m. and we will start with a roll call.
Roll call. Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner Mesner.
Here.
Commissioner Oath.
Here.
Commissioner Robbins.
Here.
Commissioner, you have 5 of 5, or Chair, you have 5 of 5 commissioners present.
All right, 5 is a quorum. We will re-engage in docket 2405-00115. At this time, we have closed cases in chief, and while it wasn't on the final pre-hearing order, which indicated we would go directly to deliberations, we're going to make an audible and we're going to go to rebuttal. We do have time allocations set aside for rebuttal. I'm going to call the parties in order, starting with Geothermal Rising, who has 27 minutes and 52 seconds of rebuttal minutes remaining. We'll then move through Southern Ute Indian Tribe, ALJ, Larimer, Fort Collins, 350 Colorado, Weld County, Western Rural Local Governments, and Green Latinos in that order. We had talked a little bit yesterday about whether commissioners wanted to provide input into areas of rebuttal, and I think commissioners are kind of just wanting to hear from the parties with regard to rebuttal. So we're not going to identify issues. There's not a lot, so we hope folks will be able to key in on the key issues for us in this deep geothermal rulemaking. Having said all that, hearings manager Smeltz and/or Ms. Amaro, if we could elevate Mr. Lepore for the first rebuttal. Good morning, Mr. Lepore. I don't know if you heard sort of the preliminary takes. We're not necessarily issue identifying. We're just going to hear from parties on rebuttal and then move to deliberation. And you are first with 27 minutes and 52 seconds. Did you want us to elevate your witnesses at all, or are you just going to speak to us?
I would like you to elevate Dr. Jones.
Okay.
And more urgently for the moment than that, you might be able to tell that I'm on my phone and not my computer. I am having technical difficulties this morning. So
would you like us to move to a different stakeholder and get back to you in just a bit and give you a chance to get onto your computer?
I would greatly appreciate that and apologize for that. I don't know what's going on. I think I'm at the, shut it down and reboot stage. I hope it doesn't take long. Obviously, if I have to, I can come back in through the phone. But if you don't mind giving me a little bit of time, that would be great. And I'll get on as soon as I can.
Okay, that sounds good. And it's in no particular order with regard to rebuttal. Everybody rebuts each other, so it doesn't really matter who goes first, who goes second. Do we have Mr. Ships from the as the attorney for the Southern Ute Indian Tribe? And we might also elevate Ben Boudreau, our AAG, that I believe has had some discussions with Mr. Ships. And Mr. Lepore, you might want to unvisualize at this point.
Thank you.
Good morning, Mr. Ships.
Oh, good. See, despite the challenges of technology, so far I think I've been able to sign in. So good morning, everyone.
Good morning.
I just wanted to report back to the commission based upon the conversations that we had yesterday. Following the conclusion of the hearing yesterday, Mr. Bedreau and Ms. Radcliffe and I did participate in a conversation regarding the tribe's proposed rule changes. We reviewed all of the document, or we reviewed all of the language that was set forth in the tribe's Exhibit 7. And if Ms. Radcliffe would pull that up, I would appreciate it. With respect to what we discussed with Mr. Boudreau, the proposal that we currently have would be to, and Mr. Boudreau can certainly speak to this as well, but I think we have agreement as to item number 1 and also the language that the tribe proposed with regard to item number 2. As a result of our conversations yesterday, our pending proposal would be to drop the tribe's request on language number 3. And moving over to the next page, I think that we have tentative agreement with regard to item number 4. And with regard to item number 5, and let me just say that this particular language corresponds to the item that we dropped under our request number 1, which addresses, which, as we proposed, address both ownership and jurisdiction and preserve neutrality with regard to issues involving non-tributary groundwater within the boundaries of the reservation. And as a result of the conversations we had with Mr. Boudreau, consistent with some existing rules that already exist with the Division of Water Resources, we propose dropping the reference to ownership. And because these really are operational rules for ECMC under the Series 1300, instead of having that broad statement about the state of Colorado, our proposed language change would limit that to the ECMC, so that as between the ECMC and the tribe, there would be agreement that these rules do not answer the question of jurisdiction over non-tributary groundwater. Again, earlier this morning, we sent precise language changes to Mr. Boudreau for his consideration. He may also need to confer with other parties, but I think we're very, very close, and appreciated the willingness of the commission to allow us to have that conversation with Mr. Boudreau, and very much appreciated the conversation. I think we've got a good end product. With regard to item 6, we also tentatively, I think, reached agreement that proposed language was acceptable. So Mr. Boudreau may have additional comments to add on that, but again, we really appreciate the willingness of the commission to engage in those conversations.
Very good. Appreciate that. Mr. Boudreau, do you want to add anything at this point?
The only two things I'd add is, first, a big thank you to Mr. Ships and Lindsay Radcliffe for working with staff to hammer out some mutually agreeable language. I think Mr. Ships described the agreement accurately. And as Mr. Ships indicated, as to point number 5, we're waiting to hear back from one other party to see if they have any objections to point number 5. But otherwise, I think all of the language Mr. Ships sent over this morning is mutually agreeable to Southern Utes and staff.
Okay. Well, that's fantastic. Appreciate the cooperation and collaboration on the parties on these points. Let's hold off on further consideration until we hear back, Mr. Boudreau, from the other agency, and then we can wrap this up here in a bit. Mr. Ships, I don't want to feel like you need to listen in to the rest of the thing. If you want to, great. If not, I know how to find you if we end up with needing some additional discussion with you. Greatly appreciate the tribe's participation with us in this rulemaking, and I'm pleased that we're able to get to a collaborative place where everyone's kind of in agreement. Any commissioners with questions? Commissioner Cross?
Thank you, Mr. Chair, and thank you both for your work on this. I just wanted to clarify really quickly, and I know we will see the language once we hear from the other agency, but you said on point number 5, you're dropping the ownership part of it. keeping the jurisdiction part of it. And then I believe you said getting rid of the reference to Colorado. And so I was just curious how that might look, because you're talking about the jurisdiction and it says of either the state of Colorado or the Southern Ute Indian tribe. And so I was curious how ECMC fits into the jurisdiction aspect of that.
Well, the language that we proposed was very similar. Our original language what we proposed with regard to item 5 was very similar to language that currently exists in regulatory provisions that have been adopted by the Division of Water Resources. And that language actually does speak to the that there's neither party is deciding jurisdiction over non-tributary groundwater within the boundaries of the reservation. When we proposed language to you, ECMC, in this rulemaking, we tweaked that to include ownership or jurisdiction, just so that there's no question about what we're submitting as being consistent with the existing rulemaking of the Division of Water Resources. What we propose doing is dropping the language of ownership. So it's almost identical to what you currently have. Division of Water Resources already has in their existing rules. The second thing we did was, rather than have this language go beyond ECMC, we struck state of Colorado, and in its place we'll just put ECMC. So essentially that statement would be that ECMC, that neither the Southern Ute Indian Tribe nor ECMC views these rules as affecting jurisdiction over non-tributary groundwater within the reservation.
Perfect.
And so it's slightly
That latter part makes more sense. Okay.
right. Slightly narrows what we had suggested, and I think it anyway limits it really to ECMC, and so you're not speaking for the entire state of Colorado,
Okay.
which I think still works.
No,
So,
I appreciate that. I just, the way it was explained at first, I thought it was just substituting ECMC in Colorado the way it's written. And I was curious about how ECMC jurisdiction would be put up there. But the way you just phrased it makes a lot more sense. Thank you for the clarification.
and just one follow note, I guess our intention would be, Mr. Chairman, if this is the way it would work best for the commission, is once we hear back from Mr. Boudreau, we will either file a new Exhibit 8 that shows the language as modified, or a revised Exhibit 7, just so you have something in the record that shows this is the language that we have discussed.
Yeah, either approach is fine. Mr. Boudreau will be getting back to you here shortly this morning, and we will clarify the record with the final revised agreed upon language. Great, thank you very much.
Thank you very much.
Let's go to the Allied Local Government Group next. That means elevating half a dozen lawyers. Oh, I see Mr. Lepore may be back with us. If he's ready and able, we can go to geothermal rising. Ah, looks like your computer's working.
Turn it off and start over.
Always a wise move. Mr. Jones, if you want to visualize yourself, we will go ahead and hear from Geothermal Rising. They have 27 minutes and 52 seconds in rebuttal.
Good morning, Chairman and Commissioners. Thank you again. I hope not to take all of the time that we have and give some of it back to y'all. There are a few specific requested changes from either Larimer County or Allied Local Governments or 350 Colorado that we would like to address. And then I think we'll have a little bit of an overarching response or closing statement, if you will. First, I'd like to talk about Larimer County's proposed change to Rule 1320 C2 And this goes to the used and useful and a local government asking to have a well plugged. To be honest, Mr. Sura blazed through his presentation yesterday, and I'm not 100% sure I have all the details correct. But I think what Larimer County is asking for is that the 3-year time period by which an operator would have to apply to convert their well to a geothermal well, he wants that clock to start running yesterday rather than 3 years from now. That's what I understood him to say, that rather than 3 years starting after these rules would take effect, if the well has already been inactive or low producing, then that 3-year clock has already started running. If I have that wrong, I apologize. If I have it right, we strongly oppose. Because if you're an oil and gas operator right now with a low producing or inactive well, you didn't know this rule was coming and you had no reason to maybe make that application to convert it. And you should have the full 3 years that the rule as written would allow you to make that decision, to decide that that would be a good use of your well. On the flip side, if you're a geothermal operator and you're thinking about where should I go shopping, as it were, for wells to convert, you didn't know that you had a time frame, a deadline, or that the well who you might want to convert is no longer eligible as of whenever these rules become effective, because in effect the rule applies retroactively. So hopefully you followed that. All we're saying is leave it as it is. There would be a 3-year time period after these rules take effect by which the operator would have to say or apply to the commission to say, we're going to convert this well. That's our intended use. And Mr. Sura can respond if I have that right or wrong. Mr. Sura also spoke about 1311E, which was a new add to the revised rules requiring a surface use agreement for an operator who is asking to have a well converted. He quoted a bit of our pre-hearing statement, I think, or a response statement, in which we said we don't see this arising very often. That is still true. I don't really understand how this would arise, but we don't oppose the language that's been added. We're fine with that because we don't think it's going to happen very often. Rule 1311F, Larimer County wanted to require a Form 2A, now called a Form 2G, on well conversions. The staff's draft requires a Form 2 permit to drill. We believe the Form 2 is the appropriate form. A Form 2 permit to drill is all about the wellbore. A Form 2G is all about the location. In this case, the location isn't changing. In the past, changes like this have been handled by a sundry notice, a Form 4. That sundry notice allows the director some discretion to ask for additional information if he or she is so inclined. And so we think all of those are appropriate for the change that a converted well would bring. And again, so we would keep it as is with staff's draft. Again, Larimer County wants the threshold of ownership to rise from 45% to 51% on geothermal resource unit applications. So the operator applying to form a geothermal resource unit would have to demonstrate that it owned or had agreements for greater than 51% or greater of the resource of the mineral owners or resource owners within the unit. The statute for oil and gas is 45%. That statute was the subject of legislation in the most recent session. The legislation changed several things about the oil and gas pooling statute. It did not change the 45% threshold. We believe keeping a consistent threshold of 45% is the right solution. With that, I think those are the sort of, I don't mean it in a derogatory way, but the nitpicky, the more specific, detailed changes that some parties asked for, and then we wanted to respond to those. Zooming out a little bit, I think there are some things that most of the parties agree about. Most of the parties seem to be enthused about the opportunity of geothermal energy in Colorado. Everybody says they want it. There seems to be a lot of agreement that there are, as Ms. Burke yesterday described it, some known unknowns. We know there are lots of different kinds of geothermal operations, from advanced geothermal systems to enhanced geothermal systems to bilateral geothermal systems. Dr. Jones can correct me because I know I got that term wrong. And the kinds of things that gradient geothermal is doing. There's an array, and all of those things will have different operational considerations. They will have different degrees of adverse or other impacts potentially. We don't know what those are. We don't know which of those technologies will be successful in Colorado. We don't know when that's going to happen, and we don't know where that is going to happen. So there's a long list of known unknowns. Allied local governments, 350 Colorado, Larimer County, their approach is, by their own words, a precautionary principle approach. They want you to apply all of the bells and whistles that go along with oil and gas development. That is a very, very, very mature, long-lived industry here. Many of those bells and whistles having been adopted in the last 10 years of about 160 years of oil and gas in Colorado, and there are roughly 40,000 active wells and thousands of new permits and applications and new wells drilled every year. So we don't agree with that approach, and we think that that approach will be detrimental to the opportunity for geothermal to take hold in Colorado. And equally importantly, we feel that those local jurisdictions that want those things can do those things on their own. They have that authority. Ms. Burke yesterday said that her group, Allied Local Governments at least, wants the state to set the floor, and jurisdictions that want to can go above that floor. I am pretty sure that that is not how Weld County feels about this, or how Garfield County feels about this, or other jurisdictions who might have the possibility of geothermal coming to their community, bringing good jobs to their community, bringing a revenue source to their community. I'm thinking about someplace like Trinidad or Los Animas County. I think they would be very interested in having geothermal there. If they didn't have geothermal rules, I'm willing to bet they'd get busy and write some if they thought they had that opportunity. So really, my overarching message is, let's not get in the way of those opportunities for those jurisdictions that want to take a different approach than Allied Local Governments and Larimer County do. We really don't have the data, along with the known unknowns. We don't know, and we'll find out, and you can adjust your rules when we do, about the impacts. But, and now I'll pivot a little bit and I want to share a screen with you. By our estimation, the impacts will be less. Give me just a second here. Can you see the screen? Oh, let's make it slideshow-ish.
Yeah, it's not in slideshow.
Yeah, I'm going to try to get it there.
There you go.
Good. Okay. So yesterday, Ms. Burke said that she looked at the geothermal in Colorado report and came to different conclusions than we did about what that report said. I don't really want to go tit for tat on this, but I couldn't help sharing a couple of quotations from that report with you.
Mr. Laporte, let me
Yes, sir.
stop you real quick. Somehow or another, your screen is dictating all the words that are being said. I don't know if that's what you anticipate or want, but
I see that. I don't know why it does that. Let's see.
this is a first. I'm applaud you on your computer abilities.
It's subtitles. It's awesome.
Thanks for pausing time, Mr. Smeltz.
Well, Mr. Chairman, let's see if I talk. Yeah, it's going to still type. I
Yeah,
don't
you
know
still
why.
got closed captioning going on.
Yeah, exactly.
I mean, it's fine. I just wanted you to be aware of it.
I mean, the alternative, I suppose, is like get out of slide presentation, but if it's not too distracting, it doesn't bother me.
Just know that everything you say is being transcribed for the world.
When there was a time when I got used to people quoting me in the newspaper, seems similar. So let's go back. So here are a couple of excerpts, you know, as I said, Ms. Burke and I come to very different conclusions. Really, what I should say is I encourage all of you to read page 234 of the geothermal report. And what's funny about that is that is exactly the same page Ms. Burke cited yesterday. So here's some of the excerpts. Drilling methods. In response to the unique needs and conditions encountered in geothermal drilling, methods have been developed that differ from traditional oil and gas drilling. These methods include drilling with air, foam, aerated water, and drilling with reverse circulation strategies. For conditions encountered in geothermal application, these alternate methodologies may also reduce damage to the reservoir and groundwater contamination potential. Even when using hydraulic stimulation, hydraulic fracturing, and note that it's even when using it because it's not always used, geothermal technology thus far has used generally simpler and less impactful techniques compared to the oil and gas industry. Therefore, water fracturing with low to zero propellant and additive concentrations is the most common and effective method to date. Now, if I could just advance the slides, it would be great. Stimulation measures other than thermal stimulation, I can come back to that, only last for between a few hours to a few days, although they have lasted longer in a few instances. This contrasts with hydraulic fracturing for petroleum operations, which generally lasts for several weeks. The lesser frequency, scope, and duration of hydraulic stimulation in most geothermal applications, as compared with oil and gas operations, will reduce both the magnitude and duration of any impacts associated with hydraulic fracturing. So our conclusion is that there are meaningful substantive differences, and you should not take up ALG 350 Colorado and Larimer County's invitation to impose the most stringent regulations you can. With that, if I could, I would like to invite Dr. Jones to share just a little bit with us about his perspective on generally on the kinds of additional measures that some of those parties have asked for, and his opinion about what that would mean for this fledgling industry and newcomers to Colorado. Dr. Jones.
Great. Thank you, Mr. Lepore. Appreciate that. And again, thanks for the commission for all of the hard work that you all are putting into this, and the staff as well at ECMC staff. Generally, I just wanted to mention that there are a lot of well-meaning ideas and proposals that other groups have brought up in this process. And one of my concerns that I have about some of these well-meaning proposals is that the compounded effect of them will prevent the jump starting of the geothermal industry in Colorado. Again, I think they're well intended or they're well meaning, but when they are coming together each one of them each one of them is great or could have a good benefits to it, but compounded, they are sort of a death by 1,000 cuts perspective, or impact on the geothermal development in Colorado. So I just want the commission to be aware of that with all of those well-meaning ideas and proposals, that I think it will dissuade geothermal developers from looking at Colorado, and it will prevent the jump starting of the industry that the governor is seeking. So I just wanted to underscore that with the commission today.
Thank you, commissioners. I think that does it for geothermal rising. Appreciate your deliberations to come.
Thank you for the closing rebuttal, whatever you want to call it. Mr. Jones, I have a question for you. I mean, as we've thought about this for the last day, and as staff has worked on this for the last 6 months or whatever, we've tried to achieve kind of the balance of creating a protective regulatory regime that also provides an ability to jumpstart, to get geothermal going here in the state of Colorado. You're familiar with other regulatory regimes with other states within the nation. And so we've got some local governments asking to go, here, we're kind of maybe here. Other local governments want to go here, down below. Where do you see the proposed regulations as drafted on sort of the scale of other regulations within the nation? And, do you see them in a place that is in that right balance?
Yeah, thank you for the question, Commissioner Robbins. And I think, as we mentioned yesterday, this approach that the draft rules as written are a good balanced approach. And it is, as we said yesterday, the Colorado way. But overall, they are more restrictive, as the draft rules are more restrictive than other states. But I think that the ECMC is taking into account the Colorado and the values of the citizens of Colorado in these draft rules. And I think that is important. That's what this whole commission is supposed to be doing. It's not, you shouldn't be doing what Utah does or what Nevada does. You should do what Colorado wants. And I think that you've struck that right balance with the current draft rules. And I do think, though, what I'm just cautioning the commission is that more additions, more requirements will prevent and dissuade geothermal developers from looking at Colorado when they have other states nearby that they can more easily obtain permits and develop geothermal resources.
Thank you very much. That's helpful information for the commission as we consider the deliberations that'll be coming up next. Other commissioners with questions for the panel? Commissioner Cross?
Thank you, Mr. Chair, and thank you again for your testimony. I really have two questions, sort of building off what Chair Robbins just indicated there. I know yesterday you talked a little bit about how even currently, where there are existing rules, a lot of companies are more likely to go someplace like in Nevada, like a Utah that has established and pretty, we'll just say less restrictive rules and faster timelines. You also mentioned yesterday that there was additional states that are looking to what Colorado has done, such as Idaho. As you look at those other states, and you may or may not heard talking, do you expect those states to use similar rules to what we're creating here, or do you expect them to try and make them less restrictive in an effort to try and encourage companies to go there?
Yes, thank you, Commissioner Cross, for that question. And I do anticipate other states are looking at what Colorado's doing, but I think that they will also be looking at what is happening in Utah, or what is in Utah and Nevada, what those rules are. So states like Washington State, Alaska, Idaho, which are looking at their own geothermal rules, I think they will see Colorado as as a more restrictive option, and they'll look at Utah or Nevada as less restrictive options or to model after. So, yeah.
So probably not a race to the bottom, but maybe going somewhere in the middle there at least. Okay.
I would imagine in the middle, yes.
Okay, I appreciate that. And my second question was more of a clarification for Mr. Lepore. And as I was taking notes here, I think I may have missed part of it. At the beginning of your rebuttal, you spoke a little bit about the 3-year time period, the 2G, and using the Form 2 instead. There was one you mentioned in between it, and you said it's not likely to happen that often. And I apologize, as I was taking notes, I missed it. So could you discuss that a little bit again? Because I believe you said you are okay with that change because you don't think that it will happen.
Thank you, Commissioner. You are correct. And the rule citation is 1311 subpart E, which requires the applicant for a conversion well to produce a surface use agreement as part of the permit application.
Okay. I thought that's what it was, but I wanted to make sure that I understood that. Okay. And then one final question, and this is one of the things that I think was talked about a little bit yesterday, was the idea of trying to strike that balance and trying to make sure, as the allied local governments and Larimer County put it as well, wanting to make sure that there's also sufficient notice. And I should mention the Green Latinos also talked about the notice. And there was some discussion of post-completion consultations, and we kind of drilled down on that and it being more notice. Do you foresee additional notice being problematic if it's done in a notice concept? So they can provide comments, they can provide input on, hey, here's additional things local governments are concerned about downhole as opposed to the siting application. If it's not an additional step in the process, it's going to add time, but it's part of the normal public comment process. Do you have a problem, or do you think your geothermal rising members will have a problem providing that additional notice?
So I'm going to try to unpack your question a little bit, Commissioner. As to notice, a concern always is, does providing notice, is that a step towards being having standing to say petition for a hearing on something. The Green Latinos have talked about notice to community organizations. That to me is a pretty undefined and nebulous term. So I don't know if those are the kinds of notices you're talking about, but something like that, we would want to understand a whole lot better than I understand it currently from Green Latinos. Other parties yesterday talked about allied local governments in particular. I think both for the local government, a relevant or relevant local government, at least maybe approximate local government, both pre-application notice and post-completeness notice. I don't foresee big issues there. That is part of, keeping everybody kind of on the same sheet of music, if possible, as between the state and the local governments. I don't see that adding time unduly to the process. So that specific tweak to the notice requirements, I don't think gives us a lot of heartburn.
Thank you.
Further questions for the panel? Commissioner Oath?
Thanks, Mr. Chair. And I just want to build on the questions from Commissioner Cross about, and that you just brought up, Mr. Lepore, about the proposal for involving and providing some notice to community-based organizations. One thought that I had overnight was, is there a way to utilize the new community liaison that ECMC is going to have to help define that? Because I understand the challenge of understanding who and when are there community-based organizations that should be consulted. So, what if there were a structure such that, if the drilling is going to occur, within 2,000 feet of residential buildings, schools, etc., within a disproportionately impacted community, then, the operator would need to consult with the community liaison. And if that community liaison, identifies that, yes, there's a relevant community-based organization, that then providing notice through that community-based organization is a way to, help ensure that potentially affected residents in the area would have notice, and if they are interested and want to be involved, that they could get involved. Just kind of curious if you have any thoughts about that type of approach.
Thank you for the question, Commissioner. I have lots of thoughts, and they aren't all aligned. One thought is that I think over the last few years, this commission has gone above and beyond in terms of providing opportunities for comment, providing, if not direct notice, then opportunities to meet and so forth. So I think where this commission is right now in terms of efforts to reach out to everyone are commendable at the very least. If we're gonna go down that path farther, I like where you're coming from on it, the use of the community liaison as that intermediary. I guess I would ask in return if the community liaison is serving as that intermediary and is kind of taking responsibility for communicating to those community-based organizations, hey, this is what's happening, and these are the ways you can be involved. Is that sufficient, or is it something that needs to be formally noticed by the operator, in the permitting rule sort of time frame? Those seem to me to be sort of nuances about how this would best be handled. That's probably as far as I can go without, seeing something specific.
Right, that's fair. Thanks for that. I know it's hard to react on the fly with these new ideas. And then I had one clarification I wanted as well. So at the beginning of your presentation, you talked about 1320 C2. So the time limit for converting an oil and gas well to deep geothermal. So the current draft rules, as I read them, says such and such, the operator must apply to convert the oil and gas well to deep geothermal pursuant to Rule 1311 within 3 years of the oil and gas well becoming low producing. So what I think I heard you say is you're reading that to mean 3 years from when these rules become effective. So I'm trying to reconcile how you're interpreting this.
So I appreciate that. I'm trying to get the rule in front of me.
Okay, yep,
too,
yep,
which
it's on page 58.
I know I'm sneaking up onto it. There
Yeah.
it is. Yeah, so how I believe this was intended and is the right way to do this is to say, once these rules take effect, then an operator who has a inactive or low producing well, the oil and gas operator has 3 years in which to apply to convert that well to geothermal if that's what's on their mind. So the clock does not start, that 3-year clock in C2 doesn't start until this rule takes effect.
So if it's a well that became low producing last year, you're saying the 3 years wouldn't start last year, it starts from those 3 years. But if a well becomes low producing next year, the 3 years starts next year.
That's correct.
Okay, thanks.
Yes. And again, so that I'm clear, I think Mr. Sura is saying something different. Mr. Sura is saying if it was low producing last year, now you only have 2 years. Right?
Gotcha. Yeah.
Yeah.
Okay.
And so if it
That's
was
helpful.
not, if it was low producing 3 years ago, you have no time. You're sort of done. And I don't think that's fair to anybody.
Great, thank you. That's all I had.
And we'll hear from Mr. Sura next, and would want Mr. Lepore, you to be sort of remain with us if we need to have kind of a dialogue back and forth. Commissioner Messner had a question.
Really
Oh, go ahead,
quickly, sorry,
Commissioner
excuse
Oates,
me, Chair
before we
Robbins. I may also find it helpful to ask staff the drafting intent there and their
Yeah.
perspective on this as well, please.
Staff, be ready to answer. Mr. Boudreau, are you visualizing? Go ahead. Why don't we just have this dialogue here now, and then we can sort of finish up this point.
So I'm clear, we're talking about 1320
C2.
C2. Yeah, so the intent there was original, I think we're talking about whether you have 3 years from the time the rules are promulgated before someone can file a 211 petition, or if they can do it essentially the day after the rules are promulgated, if it's a well that's been low producing for the last 3 years. The way it's currently written, the way it's currently drafted, it would be 3 years from the date the rules are promulgated. But that's obviously a policy call for the commission to decide whether they want to keep it like that or do something more like what Mr. Sura is suggesting, which is to sort of provide a quicker timeline for someone to file a 211 petition. But the way it's currently drafted, it would be 3 years. I would read it as 3 years from the date the rules are promulgated, because you have to be 3 years out, low producing for 3 years before this rule would kick in.
And Mr. Boudreau, what was the staff analysis that resulted in a time frame of any period of time?
That was based on the way 211 is written and the 500 series rule turning 211 into a hearing, which allows for a 211 petition to be filed 3 years after the well is low producing. So staff pulled that from the existing standards and then later recognized that there are more nuances to the 211ing of a, lack of a better term, 211ing of a geothermal well. And so, or in this case, converting an oil and gas well to a deep geothermal well. So I think maybe the parties have put significantly more thought into it than when we originally drafted this. This was meant to address 2 unique situations raised by stakeholders, and now recognize that there is an issue to resolve as to whether it should be 3 years from the date of promulgation or 3 years from when the well first became low producing.
Mr. Lepore, any response now that you've heard from staff?
Yes, thank you, Mr. Chairman, and thank you, Mr. Boudreau. I think if it's already been 3 years and you're gonna say that the day the rule takes effect, a local government can petition to plug that well, and there is no defense that you intend to use it for a geothermal well, it's just unfair. Nobody's on notice. Nobody's on notice that there's a time frame that they're supposed to say to the commission, hey, we're thinking about geothermal for this well. Moreover, you're going to take a whole bunch of wells potentially off the table from a future geothermal operator who wants to say, let's go find some low producing wells that might have a second life. Oh, whoops, that's not available because you didn't provide notice to the commission 3 years ago before this rule existed. It's fundamentally would be retroactively applying this rule, and I don't have to tell you, Mr. Chair, and others that that is not, favored to have retroactive application of rules.
Fair enough. Okay, thank you. Commissioner Messner?
Thanks. This is a good discussion, and I appreciate this because this was a topic that I was noodling on overnight. I wonder, Mr. Boudreau, if you want to visualize yourself again. I think my only concern, and perhaps it's a concern of the local governments they're trying to address, is how to craft this rule in a way that creates opportunities for converting a well for deep geothermal, and I think that's certainly the intent, but doesn't set up a situation that could potentially be abused to be able to extend, I guess, unintentionally affect how Rule 211 is currently applied and its intent by an operator designating a well at the end of 3 years as a geothermal well and just extending the ability to operate that well, I guess, in conflict with the existing Rule 211 that would create some standing for a local government to request that it be plugged and abandoned. So I just see conflict here and the potential for abuse, not that it's intended to discourage geothermal development of existing oil and gas wells, but how it unintentionally can affect the existing Rule 211 provisions. I don't have a great answer for that, but I see the potential for abuse. And I don't know if you evaluated that, Mr. Boudreau, as you were developing this, or if you see a conflict, or if you don't see a conflict that I'm bringing up.
I think that's a great point. And off the top of my head, and this is not meant to advocate for one position or another, but just thoughts. Rule 211 has been in place for some time now, and operators should already be aware whether or not their wells have been low producing for the last 3 years, and those wells would already be subject to 211 under the existing rules. The only thing that 1320 C2 is meant to address is how an operator can or cannot use used or useful as, for lack of a better term, defense, as a defense against a forced P&A of their well. And subpart 2, or excuse me, 1320 C2 doesn't prohibit an operator from using used or useful future use for geothermal as a defense. It creates a rebuttable presumption. If you haven't filed to convert it within that time, it creates a rebuttable presumption. However, the other side of that is operators were not aware that this was an option until the rules are promulgated. So I can see both sides of it. I think ultimately it's a policy decision for whether or not to leave it as is, which would, according to the way I read it, give operators an additional 3 years to file to convert their wells to geothermal wells to avoid the rebuttable presumption. yeah, I mean, it doesn't, the way I read it, I don't think it prohibits someone filing a 211 petition. As long as the well has been low producing for the last 3 years, it's just a matter of whether or not that rebuttable presumption kicks in based on whether you, the operator, filed a application to convert it.
Okay, well, interested in hearing more thoughts on that and appreciate the thoughts of geothermal rising on this one. And your thoughts, Mr. Boudreau, obviously. I did have another question. I wonder,
Mr. Chair, I'm sorry, Commissioner.
Just
can
a
I-
sec. I'm going to get back to you, Mr. Lepore. Go ahead, Commissioner Messner.
I'm going to shift to another topic. So if Mr. Lepore has a comment on this topic, that's fine. I'm listening.
Go ahead, Mr. Lepore.
Yeah, thank you, Commissioner Messer. I did want to respond to this and stay on one topic. I was gonna also add that I think the geothermal in Colorado report talks a lot about conversion of wells and talks about some of the advantages of converting wells rather than drilling new wells, including that the wellbore already exists there, so there's either no drilling or limited drilling when you're converting a well. So there are advantages to converting, and doesn't mean that a geothermal well isn't going to be put in somewhere else. So there's sort of that trade-off about, can we repurpose an existing well pad, repurpose existing wells, or are we going to go build a new pad and drill a new well? So just wanted to put that out there.
Appreciate that point. A new topic, Commissioner Messner?
New topic. I wonder, Dr. Jones, Mr. Lepore, if and probably Dr. Jones, you're going to have the most experience on this, but can you opine on this equitable compensation question and a section in the rules that addresses that? I wonder how other jurisdictions are approaching that kind of equitable compensation question, and or if they are, and whether or not you think that this is an appropriate attempt to address equitable compensation as proposed in the rules.
Mr. Jones?
I'm not sure what section we're talking about.
It's
1310.
1310. Yep.
Yeah, I'm just going to say, Commissioner Messner, I am not sure that Dr. Jones has zeroed in on equitable compensation as a topic. So,
And that, okay, I guess I'm curious about how other jurisdictions handle it, right? And this seems unique. It was brought up in other testimony. I'm just curious to get more thoughts on it. And you didn't provide any thoughts on it in your initial testimony. I didn't know if you had any thoughts.
yeah, so can I lay a foundation here?
Yeah, go.
Yeah, so Dr. Jones, this equitable compensation refers to when there is a geothermal resource unit, which is kind of the equivalent in oil and gas of a pooled unit. And so I'll stop there. If you have knowledge, familiarity, know what other states are doing, by all means, share.
No, I do not know what other states are doing regarding the pooling of equitable compensation. I do not know.
Okay, thank you.
Other questions for the panel? All right, stick around. We may want to bring you back up. And we appreciate, thank you for the rebuttal closing testimony this morning.
Thank you, Mr. Chair. Can I ask, I've been asked by another party if we have any time left, we would cede to them. I don't know if I have time left, and I don't know if I'm allowed to cede it.
Mr. Smeltz, time check.
Yes. Geothermal Rising has 10 minutes and 50 seconds left.
To whom would you like to cede some time, Mr. Lepore?
Western and rural local governments who did cede us some of their time previously.
How much time are you giving them?
Stand by. And a whopping 3 minutes.
Okay, so WRLG will now have 4 minutes and 55 seconds. And you would have 7 minutes-ish if we need you back up here. But otherwise, if I bring you back, I'm going to be asking you questions. That's not going to be allocated against your time.
Yes, sir.
Commissioners, let's take 10 minutes. Let's return at 10:11. And at that point, we would like our staff to bring up all the folks from the allied local governments. All right, we're back on the record in the deep geothermal rulemaking. It is August 6th. It is 10:11. Ms. Burke, you're recognized as the leader of the allied local governments, or at least as the first spokesperson. You've got 6 minutes and 10 seconds.
Thank you, Mr. Chair, and I am going to kick it off, and then we'll move on with some of my colleagues here. Whoops. Sure. Okay. So just running through a few points from yesterday and also from this morning. We do support the agency considering rather than deferring to local government approvals. We think this properly reflects co-equal authority, and a point to consider is that local governments don't want to defer to ECMC approval, so why would we require the other way around? The 15-day business day notice period, I did want to revisit this because I know there were some questions about it. We talked yesterday about our request for that additional time for when the director issues a conditional approval, but we didn't raise the fact that we had asked for the same thing in 2 other instances. And these 2 other instances are in our minds actually even more crucial. So I just wanted to point them out. And those are 1302C1 and 1308A. And these are for when an operator is going to make changes on an existing operation or subsequent operations on an existing pad. And these are instances that the local government would have significant interest in and potential concern about. And so the additional notice, for the reasons we described yesterday as far as timing goes, is especially important in those instances. We still want it for the director's conditional approval, but I wanted to highlight those other 2 instances. We talked about alternative location analyses. Other parties talked about our request for alternative location analyses. We do urge application of that process for all operations, but we are offering an alternative where we would apply the threshold criteria that exist today in Rule 304B2B for when an ALA is required. And then we had one additional idea that during the pre-application consultation, the parties might agree that for whatever reason in this instance, an ALA may be required. So we are willing to discuss limiting ALAs to particular instances, and we thought that was a good list from the mission change. We did find another typo, what we think is a typo in Rule 1316.C2A, and talking about financial assurances. It talks about with as a defined term, single well plugging and abandoning cost, whereas the 100 series defines single well plugging and abandonment cost. So hopefully not a big deal. Okay. Conversion of an oil and gas well to a DGO. We really do want the notice and chance to participate in that instance. We had suggested a Form 2G process rather than the Form 2 that's currently in the rules. And I believe, and I'll let Mr. Dean tell me if I'm getting it wrong here, but the reason we want the 2G is we want notice and an opportunity to comment. And a Form 2 alone is an administrative process that we may not even know is happening. And from our point of view, that conversion is a significant change that we want to know about and want to have some input into. So maybe it doesn't need to be the full 2G process with all the attached plans and everything that goes with that, but we do at least want something more than that administrative form 2. Threshold for forced pooling. The 45% threshold in the oil and gas context, as I understand it, was arrived at due to the checkerboard of mineral rights ownership that stemmed out of the railroad days and school lands days. But we don't have that in DGO. We're starting from a fresh slate. And there's really no reason that an operator shouldn't have the majority of a unit in control before they can force non-consenting people to have their property developed. So we think that raising that threshold is still important. We very much agree with Commissioner O's idea about bringing in the community liaison and indicating some openness to community-based organizations. We actually had suggested this in our Exhibit 1, which simply adds the community liaison into a couple of the different consultations. We have some thoughts about the Rule 211 timeframe issue, if you'd like to ask us about them, hint, hint, hint. And then we do ask you, we clearly, a major issue between ourselves and geothermal rising is the potential for adverse impacts from geothermal. So we did send in our PowerPoint and we pulled out lots of quotes about the possibilities of a variety of adverse impacts. And yes, we agree, there's also mention in there of ways that those may be mitigated. However, our understanding, again, with a careful read, is that a lot of those were new and even speculative and may or may not be typical. But again, as we mentioned yesterday, that may be an opportunity for later right sizing if needed. And then finally, to some of the points that we were just discussing with Mr. Lepore, strong regulation has not killed the oil and gas industry, despite vociferous objections that it would do so. And so we ask you not to race to the bottom, which is essentially what they're asking. If they're saying, oh, Utah's the easiest state, so you should be just as easy, what is that other than a race to the bottom? In fear of these familiar arguments that have not panned out. And so I'm going to let Ms. Paraños add a little more meat to that comment.
I don't have much time, but I do just want to underscore that we have proposed what we believe are very reasonable requirements for the engines and associated equipment used during drilling and completions. These recommendations are based on the use of demonstrated technology that is required for oil and gas operators in the ozone non-attainment area. And we have built in an additional exception for requiring the cleanest engines only where technically feasible.
That's
Thank
fine,
you.
Ms. Paraños. I'm now asking you a question to elaborate more fully on this point, followed by a question to Ms. Burke about 211.
Thank you so much, Chair Robbins. So what we did for our engines proposal is we looked specifically at the Air Quality Control Commission's Regulation 7 requirements that are aimed at reducing oxides of nitrogen from engines and associated equipment used during the drilling and completion of oil and gas operations in the Denver Metro North Front Range non-attainment area. We took those requirements, and as I mentioned, we added in an additional exception that only would require the use of the cleanest, and that would be electric drill rigs during drilling where technically feasible. We did extend the requirement statewide because we do believe that utilizing the cleanest engines, it not only reduces NOx, which is just critical in our opinion in the non-attainment area, given our severe ozone non-attainment status with the 2008 standard, and are continuing we continue to be downgraded for both the 2015 and 2008 standard. But in addition, we propose these requirements statewide because using dirty diesel engines also emits hazardous air pollutants, including benzene, which is a known carcinogen, and does impact the health of persons that reside nearby pre-production activities. And as I mentioned, we feel very strongly that you have a duty to protect public health, as well as to promote clean, renewable sources of energy, which we absolutely support. We simply think that we need to utilize those technologies in a way that will not have any indirect adverse impacts to health or the environment. And so that's the basis of our suggestions.
Ms. Burke, before you address the 211, can you comment? Again, I'm not sure I agree that where staff has landed the draft is the quote race to the bottom, or that it is similar in scope to Utah, Nevada. In fact, Geothermal Rising, whom I assume is testifying credibly, has indicated that the balance that's been achieved in staff's draft is actually the most robust regulations in the nation. So would love to hear kind of how you equate that to a race to the bottom and being similar to some of the other states that have a 3 to 4 week permitting system.
Yeah, and I threw out that that phrase on purpose, and I have not looked at Utah's rules, and I'm sure Dr. Jones is more familiar with that than I am. I was just referring to the sort of concept that what I heard them saying is that Utah, Nevada, maybe Idaho have easier pathways to permitting, and therefore we should move more in their direction. I'm not saying that the current rule is that. It sounded to me like they were urging you to take in this. Well, let me back up. So again, to one of our core disputes, which is where and what are the adverse impacts from DGO, we're saying take the precautionary approach. They're saying don't do that, take a more open approach to promote the industry, more similar to what these other states have done. So I'm not saying that you are racing to the bottom. I'm saying that it seems like what they're doing is asking you to slide down that continuum in order to give them an open door. And I did, Ms. Copeland, who I think is online, I hope, had some comments about the differences between some of those states and our state, and why some more strict protections are really appropriate here. So do you want to hear from her if she's up with us?
Yeah, go ahead, Ms. Copeland.
Yeah, thank you. Thanks, Kate. So yeah, on the air quality side, I did want to make the point that some of the other states that have been made in comparison today, I've heard Idaho, Utah, I think maybe I heard Wyoming mentioned, and Nevada. So just when you're talking about air quality, we have the the pleasure or the displeasure of being a much more extreme non-attainment area in the Denver Metro North Front Range non-attainment area. So there are 2 different ozone pollutants that we're classified for, and we're classified as serious and severe. We probably are likely to be classified as an extreme ozone non-attainment area. And the other states mentioned don't have, Utah doesn't have any ozone non-attainment area. I'm sorry, Idaho does not. Utah has lower classifications, they're moderate and marginal. And Idaho, I'm sorry, I've mentioned Idaho, Wyoming has a marginal area, Nevada has a moderate area. And so, that's kind of because of our location, the way we have the mountains and the Front Range, the situation, but it's also, we have a lot of oil and gas. I mean, I know a couple of those other states do, but we just have unique circumstances that make our air quality a lot worse. And so, that's why we at least, want to consider extra protections in this ozone non-attainment area, because, knowing this is a cleaner energy source, we don't think it makes sense to start it out at, using like dirtier equipment than oil and gas is required to use in some instances in this non-attainment area. We really think it's important to start it out is, using the same level the oil and gas is required, knowing that maybe it's, shorter time periods and, not as many wells, but it just makes sense to start it out this clean energy source, starting out as clean as it can be to really protect our non-attainment area. Because I don't know if you've been noticing, but if you get air quality alerts, we've had an air quality alert in this area every single day for the last, I don't know what. I mean, last time I looked, we were at 35, and that was like 5 days ago or something for the summer. So we really just, need these protections, and this is equipment that's available and in use. So we just really want to make that point.
Thank you for the point. Ms. Burke, you're out of time, but I did ask a quick question around 211.
Yeah, and I was just talking with Mr. Sura, so he can elaborate on this too. But I just wanted to clarify, I think there's two different issues in the discussion around this Rule 11. One is, when does geothermal operations rules come into effect so that an application even can be filed? So that's kind of the retroactivity question. Obviously, they can't apply today. So that's one question. But then there's another point to this, which is, let's say 5 years down the road, so we're well into deep geothermal. If the local government goes in at that point and says, okay, well X has been low producing for 3 years, and we, for a variety of reasons, we think it needs to be plugged. The way the rule was written originally, the operator can then say, oh, but I'm going to switch that to deep geothermal, and they potentially then just get themselves another 3 years during which we trust that they're going to do that in that, ensuing 3 years. Do we come back and reconvene to check? So it's just there's the retroactivity point about when the rules become possible, but then there's also what happens in the future. And so Mr. Sura had an idea that just on a very quick look seems to work, where they have until, for any Rule 211 petition that comes in, if they want to raise the defense of using it for deep geothermal, they have a year following implementation to actually do that. And then thereafter, they have to have made that application within that low producing period, if that makes sense. So they don't just buy an extra 3 years by indicating an interest. So I just wanted to point out that there really are two issues to solve. And I think Mr. Sura is getting close to a good idea that solves both.
Great. We'll hear from Mr. Sura next. Questions for the panel? All right, seeing none, thank you very much for the rebuttal and/or closing. We do appreciate it. Let's move to Larimer County and Fort Collins with Mr. Sura.
Good morning.
Good morning, Mr. Sura.
I'm going to share my screen quickly. Hopefully that works.
Yep.
Okay, great. I appreciate the opportunity to speak with you again, and I'm sorry for rushing through. I knew that I was going to need time for a rebuttal, so looking forward to chatting with you today. One of the issues that came up in API's response is that they didn't feel that there were any circumstances that should warrant or allow for the opportunity for a hearing. And I just wanted to talk to you at least about the one that is number C here. A hearing is requested pursuant to Rule 507 by any party entitled to consultation pursuant to Rules 1303 or 1304. And again, who are those folks? It's local governments. In 1305, it's surface owners, the actual surface owner, building owners and tenants within 2,000 feet, schools, childcare centers within 2,000 feet, CPW, CDPHE, water system if it happens to be implicated, state land board if it happens to be on state land board land, Division of Water Resources if those issues come up, tribal governments if those issues are involved, or Bureau of Land Management if it's on federal land. Now, I don't see any reason why these folks don't have the right to request a hearing before you all if they feel strongly enough to file a petition for a hearing. I think that you would be interested in hearing what their concerns are. That these folks would rise to the level of people that you would really want to benefit. You would benefit, the decision would benefit from hearing from them. And so I encourage you to consider that as some folks that should be entitled to hearing. Due process for a geothermal owners. Again, we've got a right now. It's a property right. It's one of the sticks in the bundle of sticks that we have as property owners. We now have a geothermal right. And that was in Senate Bill 23-285. It's there if you need to see it. But as a property right, if that's going to be taken or in some way used without that property owner's permission, they have some due process. And that includes notice. I believe that it would benefit everyone if they had an opportunity to attend a hearing and the opportunity to present some evidence, at least an appraisal as to what they think, that they're, that they should benefit, how they should benefit from the use of their geothermal resource. And that doesn't have to be in front of you. That could be in front of a hearing officer. It could be done quickly. It doesn't need to stall things, but there should be some process. And right now there's none. Moving on to the 211 claim, this is the language that I proposed yesterday after hearing your discussion. I wanted to make a change and added some additional language. So the way that it reads now is that operator must apply to convert oil and gas wells to a deep geothermal wells. I'm right here. Pursuant to Rule 1311, within 1 year of the effective date of these regulations, I'm assuming it's going to be November 2024, or prior to the application being filed for a 211 hearing thereafter. And if the operator has not made such an application, there's a rebuttable presumption that the oil and gas well is not used or useful for deep geothermal operations. It doesn't mean that they can't bring that up. They still have the opportunity to raise their hand and say, we intend to use this for deep geothermal, but there's a rebuttable presumption that they must overcome that, they haven't done it so far. Clearly you had an opportunity to, and you chose not to. There's a rebuttable presumption that I think that makes sense in that case. Finally, in Rule 1311, again, this came up with API and geothermal rising. The ALJ as well. I think that ALG as well as I think that this is right, that there are certainly instances when we're going to be converting a well from oil and gas well to a geothermal well, that should rise to the level of requiring notice, at least to the local government. And in some cases, I think that it certainly requires a Form 2G location assessment, because we all know that things have changed since these wells were drilled in the 1970s and 60s. And if they're completely surrounded by a neighborhood, it may not be appropriate use. So I'll leave it at that, and I look forward to having a discussion and answering your questions.
Questions for Mr. Sura? Commissioner Messner, then Commissioner Cross.
Thanks, Mr. Sura. I note that you didn't bring up any additional information about equitable compensation, so I didn't know if you had any further thoughts on that, or
Yeah, and I didn't come up with a red line, although I gave it a shot last night. But I really do believe that it warrants additional stakeholder discussion. However, I think that the minimum that you would want to address in such a regulation would include what I put there for a due process for geothermal owners, that they have notice that they're geothermalized, that they have an opportunity to attend a hearing, and they have an opportunity to present evidence in the form of an appraisal. And then you would have that either go before a ALJ or a hearing officer, could ultimately go to you if you chose to have it go to you. But I think to streamline things, it would make sense to have this go to a hearing officer. And again, this is the kind of the minimum I think is due to someone who's having their new property right utilized against their will.
okay. And my other question is, understanding that the rules do give discretion for the director to push an application to a commission hearing. The commission also has the authority to be able to pull an application up for a commission hearing for any number of reasons. What's the advantage of being prescriptive versus leaving that kind of flexibility and the discretion as to when it would be pulled up either by the commission or pushed up by the director?
Well, that's an excellent question, and certainly if we had you all on a life sentence on this commission, I wouldn't have as much of a concern because you are really receptive, but we're not always going to have you as commissioners. And these rules are meant to, outlive you. And I think that certainly school districts, should have the right to request a hearing if they feel that there's going to be a concern with a new well that's drilled within 2,000 feet of their playground. It is not only assures them the right that they can speak to those issues before the decision maker, but it also gives them a little bit of negotiating leverage, frankly, with the operator. If they say, look, we'd really like to have you consider only doing that drilling during the summer when school's not in session, and they say, go jump in a lake. If they have the right to a hearing, that helps them in those negotiations, and maybe the operator is going to be consider, yeah, we could probably do that drilling during the summer, so it's not going to interfere with the school day.
Okay, thank you.
So while we got you both, we went ahead and re-elevated Mr. Lepore. We're trying to sort of hone in on this 211 issue, and having both of you talk to us at the same time probably makes a lot of sense. So first, Mr. Sura, I don't know if you felt like you didn't have enough time. Did you want to weigh in further on 211? Otherwise, I'll let Mr. Lepore weigh in so that we can hopefully get to a good spot here.
Again, so having heard the discussion and having heard Mr. Lepore and geothermal rising on this issue, I do recognize that there needs to be some amount of time to allow for operators to look at the possibility of converting their well to a geothermal well. And I don't think it's 3 years, frankly. I don't think that that's necessary. Even if we were to allow for a year, that's going to stop a number of 211 hearings from occurring that have even been filed. So the decision here to allow for a year after these regulations have become effective is already going to prevent a number of wells from potentially being plugged and abandoned that should have been plugged and abandoned 30 years ago. There's more than 4,000 wells on the Front Range alone that are low producing for over 3 years or completely non-producing for more than 3 years. So there's a need. 211 fills a need to clean up oil and gas fields where there's higher, better use because these wells aren't producing at all. And to allow for a full 3 years means that it just is going to forestall any cleaning up of the oil and gas patch. More than that, this is also going to be the same discussion that we're going to have in December when we're talking about CCS. All of a sudden a carbon sequestration well, that should be, be able to be an excuse to be able to forestall plugging a well that's no longer used or useful. And, then they get another 3 years. I think that doesn't make any sense. I think that this is a solution that does make sense. It gives a full year after the enactment of the rules to investigate the possibility. And then after that, if they haven't thrown up their hand and said, we'd really like to see these wells used as a geothermal well, then there's a presumption that they didn't intend to do that and they're probably not suitable for geothermal.
Thank you. Mr. Lepore, any Sir rebuttal, I would call it?
Thank you, Mr. Commissioner, Chairman. Yes, I have some Sura rebuttal for Mr. Sura. I will offer a counter proposal. And that is that the first condition is that the well in question had already been shut in or low producing for 3 years when these rules take effect. And after, if that is true, the operator gets 1 additional year to apply for the, to say, we think these are used and useful for geothermal wells in the future. Ms. Burke made a reference to making an application, and you can't do that until these rules take effect. I think it's slightly less formal than that, but I won't go down that rabbit hole. The rule states right now that the local government cannot even make this 211 application unless the well has been inactive or low producing for 3 consecutive years. So let's say that right now the well has been inactive for only 1 year. You automatically have 2 more years before the well is even eligible.
Correct.
So I think a fair solution that gives people some notice that if you're serious about the potential for this well as a geothermal well, condition 1 is it's already shut in for 3 years when these rules take effect. Condition 2 is that you have 1 year after that, during which obviously the well still has to be shut in or low producing. Then the petition could be filed and the rebuttable presumption would apply. And I hear Mr. Sura and Mr. Boudreau that it is a rebuttable presumption. It can be overcome. I understand that. It's still a change in the burden of proof and the level of effort required by the existing oil and gas well owner.
If I might
Mr.
respond.
Sura? Yeah.
Thank you. Mr. Lepore, I think that that's an excellent idea. And that's what I think that this accomplishes, this new language. You're absolutely right. You don't have the right to file a petition to have a well plugged and abandoned pursuant to Rule 211 until the well has been inactive or low producing for 3 or more years. And so you wouldn't even have the opportunity to do that. This is going to forestall any new applications for a year from the effective date. And that does give an opportunity for the geothermal folks to start talking to operators, and for operators to consider whether or not that this is a good use of their own wells. So I think that is a compromise that we could all live with, and I hope that that's true.
So you're in agreement with the proposal Mr. Lepore put on the table?
And I think that the language that I put forward, and I can share it again, accomplishes exactly what he was proposing.
Mr. Lepore?
So I'm going to have to read fast here.
Well, why don't we do this?
No.
Why don't you,
Yeah,
Mr.
that's
Sura, share your language to Mr. Lepore via email. Mr. Lepore, take your time with it. Let's go to the other parties and we'll come back to this topic at the end. Fair?
Yes, sir.
All right. Let's move to 350 Colorado. Heidi, oh, I'm sorry. Commissioners, does anyone have questions of Mr. Sura? Or further questions of Mr. Sura? Commissioner Cross?
Thought I hit on mute, but I guess I didn't. Thank you, Mr. Chair, and thank you, Mr. Sura. The majority of my questions were already asked by Commissioner Messner. I just wanted to expand a little bit on one of the questions that was raised, specifically as you were talking about the right to request a hearing. One of the proposals that has been brought forward by Green Latinos is to also have consultation with community-based organization groups. If that was the case, would you also foresee community-based organization groups getting to raise a hearing if they so chose?
Well, if that was the will of this body, you could add them, certainly. You know, the questions that you would have or I would have, in your place is, how do you define who those are? But yeah, I think that if there's a definable community-based organization that represents that group, that community, it would be wonderful to have, their input on these issues. And honestly, I think that these are going to be great conversations to have. In the most cases, if you're going to be all of a sudden bringing free heat to a school, as an example, I think that they're going to be on board and they're not going to have any concerns about it. In the event that they have concerns, if I were in your position, I'd want to hear those concerns. And not have that, be something that, doesn't make it through the director, frankly. And again, this director is not somebody that would want to keep those kind of concerns from you, but these are rules that are supposed to outlast all of us. And so, I think that there are folks that are, we've required consultation of those entities, and those entities, if they have real concerns, they should be able to bring those to the commission, to the ultimate decision maker.
Yeah, thank you.
Any further questions of Mr. Searle? All right, seeing none, if you could email your language to Mr. Lepore, and the two of you chat that up just a bit, we'll bring you back here in just a bit. Ms. Leithwood, welcome. On behalf of 350 Colorado, you have 2 minutes.
Hello, Commissioners. First, I'd like to restate our request for a change to the SBAP to commit to a second rulemaking, but mainly I'm focusing my comments today on greenhouse gas emissions as a climate organization. Other parties haven't focused on this, and so I want to really make sure that it's not missed in the shuffle. Well casings are well known to degrade and leak, both new and old casings. Common sense tells us this will happen the same, if not more, to old oil and gas well casings under the high temperatures and pressures of geothermal. We're asking for rules both to prevent these leaks and to learn more about them. This precaution is not unreasonable. It's a known impact that we can prevent. Our recommendations were created in consultation with Dr. Tony Ingraffia, who's conducted extensive research on well casings, and I'm happy to answer questions about his qualifications. And I'd like to quickly share my screen. Hopefully I'm sharing this on the.
It's not being shared just yet. Okay, now you are.
Yeah, so here are some specifics about our recommendations for repurposed oil and gas wells prior to approval.
Okay, wait. Mr. Smeltz, stop the clock. You're sharing a screen that says PowerPoint for Mac Help. It doesn't seem to be relevant to.
Okay.
Just take your time. Clock's not ticking.
Gosh, I'm really sorry.
It's okay.
Okay, try again. Let's try this. Is that
There you
working
go.
now?
350 Colorado rebuttal.
Okay, yeah, thank you. So for repurposed oil and gas wells, just to increase the requirements for logging and testing prior to approval, and then including monitoring for methane leakage. And then after completion to require quarterly mechanical integrity testing, and then annual corrosion inspections. And then for new wells, we'd like them monitored during drilling and after completion for methane leakage. And then if it is found, the same quarterly testing should be required. And then if carbon dioxide is used as the material medium for heat transfer, to require plans for monitoring and containing carbon dioxide leaks. And I will note that in the rules currently, the corrosion inspection frequency is 5 years. And so we really think that you should change that to annually. We do have some proposed language in our red line, although it needs to add the concepts in red above. I could share my red line with you on screen share if you have any questions about that. And I've probably used up my time.
If you want to share that screen, I'll act like that's a question for me and we'll get this final piece put together for you.
Thank you. Appreciate that. And
Okay, we can see that.
can you see
Go
it?
ahead.
So as I mentioned, I did not yet include the language for continuing to monitor for methane leakage. But here's the red line for 1311 for converting well bores. And of course, the staff drafter can probably edit it to be more in line with the way your rules are usually written. And then here's for just adding requirements to mechanical integrity tests. And if the wells show lack of integrity, or they should be repaired within 30 days or plugged and abandoned within 6 months, unless the leak is determined to be substantial. And if it's substantial, it should be repaired immediately. And here's the one for geothermal wells drilled in a known oil and gas basin to monitor for methane emissions during drilling and completion. Oh, and then I didn't mention, but we would also like the results of tests and corrosion assessments and inspections to be on a public facing website in understandable language.
Okay, great. Thank you very much. Questions, commissioners?
Should I stop my screen share?
No, that's okay. I can still see everybody. Commissioner Ackerman?
Thank you. Just if I could ask you to elaborate, Ms. Leithwood, on if you scroll back up to the timing provisions that you put in there as far as the repair.
Oh, yeah, okay.
There we go. Can you just elaborate on where you came up with those timing provisions and what their basis might be? I'm talking
Well, it seems
days, 6 months.
this is the plugged and abandoned within 6 months is negotiable if you don't think that's reasonable. But repairing a substantial leak immediately is in line with what we've been also requesting for the pipeline safety rules from the PUC. And we think this is so important because methane is both a safety hazard, but also it is contributes so much to the greenhouse gases that cause climate change. So that's where the repaired immediately, if it's substantial, and I guess that would be up to you to determine what substantial was. And we think that within 30 days is a reasonable time frame to repair a leak if it's discovered. And again, as a climate organization, we're really dedicated to making sure that this new clean energy technology is the most protective that it can be for greenhouse gas emissions. We know that it has lower greenhouse gas emissions. It's modeled to have lower greenhouse gas emissions than some other sources. However, that modeling doesn't include the possibility of leaks. And we also know that leaks are a major issue. And that's why the AQCC has done their methane verification rules and is moving more towards methane measurement and monitoring. Because it's been proven that the actual methane emissions are far more than what's been shown for oil and gas. And a large part of that is leakage. And so since it's proposed to use old oil and gas wells to convert them, we really think this is an opportunity to make sure that they are not leaking and to make sure that using them isn't going to perpetuate or maybe even increase methane leakage with the high temperatures and the pressures used in geothermal.
Thank you,
This
Ms.
is something that hasn't been studied before. I've asked the Department of Energy. I've looked for it everywhere. To my knowledge, this has not been studied. And so this is an opportunity for Colorado to lead in this area as well.
Thank you, Ms. Leithwood. Thanks for your continued efforts to protect against emissions as well. I appreciate the hard work that you and your organization does. I understand philosophically, I was just looking for more where those numbers came from. And I think the response was that that's something that Colorado 350 feels is appropriate and generated. So I appreciate your response. Thanks so much.
Thank you, Commissioner Ackerman.
Any final questions? All right, thank you, Ms. Leithwood. Again, appreciate your presentation and being with us.
Thank you, Commissioner.
I think let's try to get through the rest of the parties before we return back to Sura and Lepore. Next is Weld County. Oh, hello, Mr. Maxey.
Hello and good morning. Thank you for just a few minutes here. We'll keep our comments brief and just mainly wanted to make a few final comments here. First off, my apologies for not being able to join yesterday. I appreciate our Assistant County Attorney, Matthew Conroy, being able to provide our presentation and answer some questions. But in general, I just wanted to pop on this morning and make a few comments and then see if Matt has any final closing comments as well. We want to make sure to make the comment that we are in favor of maintaining the same setbacks as currently reflected in the oil and gas rules, especially considering and respecting local governments and our local land use process and authority that we have as well. And the setbacks, we believe that they're working fine for oil and gas, and we would recommend that they stay the same for deep geothermal. Weld County, as you all know, is supportive of multiple energy types and developments, and we will maintain that with geothermal and this new technology coming online. We're excited to work with some additional companies and groups to be supportive of this technology through this rulemaking process and through Weld County's local land use rules as well. And we'll continue to consider different energy sources and technologies such as deep geothermal on a case-by-case basis for all siting, considering private land use and private property rights especially, and in addition to the health, safety, and welfare of our residents and of the environment, just like what we do for our oil and gas WOGLA process, as you all are familiar with. So with that being said, I just wanted to thank you again for the time to get on here and pass it over to Matt if he's got a couple closing comments.
Thank you, Director Maxey. I guess the only thing that I would add is we would reiterate our request to maintain defer instead of consider in Rule 1304 that matches, again, the current oil and gas rules. That was heavily litigated in the mission change rulemaking. We don't see any real reason to change it to consider. And we think, again, as Mr. Maxey was saying, that local governments have the best understanding of local siting conditions. And so it makes the most sense to defer to our decisions as long as we're taking all of the relevant information into account. And with that, we're happy to answer any questions.
Anyone with questions? Thank you very much. Appreciate you being with us.
Thank you.
Kirby Wen is recognized, the Western and Rural Local Governments. Mr. Nguyen, you now have 4 minutes and 55 seconds after receiving some time from Geothermal Rising.
Excellent. Thank you very much. Shouldn't need nearly that amount. In response rebuttal, I guess, one element is we do take issue with the ALG group appealing to you to adopt their more overreaching proposals, if only to, and the reasoning they had was to protect smaller local governments with supposedly lesser permitting and rulemaking participation resources. That doesn't make any sense, and it seems inappropriate in a venue like this. The simple fact is that ALG has made no real credible showing in what are unfounded presumptions of adverse surface impacts for deep geothermal being anything akin to oil and gas development. And the rest of Colorado really has no need for ALG to interfere with and overrun their local processes here in this rulemaking. We know that every local government has their own approach to land use permitting that works for them without need for any sort of unwelcomed interference by other parties. Also, speaking to the defer, again, just briefly, we again reiterate the importance of not changing Rule 1304 303C3 to replace defer to with the word consider regarding local government siting disposition. Well-meaning as the staff intent with this change may be, we think that the implications are less than clear on what that change would cause and upset. We also believe the underlying problem with existing Rule 302C3 for the oil and gas rules, the underlying problem with the use of defer to currently that's presumably spawned this rule edit has not been shared with parties. And so we haven't really had a chance to really thoroughly think through what staff's intent was there and why they think there's a need. In our experience, so far, there's no problem to solve therein. The current language in effect for oil and gas was heavily litigated, as also mentioned by Will County during the mission change rulemaking. It resulted in what we believe is a well-functioning process. And we ask you not to switch to will consider at this time, and not until a clear need for such a change is identified and stakeholders are provided opportunity to weigh in more fully. Again, also, we reiterate our support for the 500-foot setbacks for deep geothermal. We haven't seen anything credible to support any sort of need for 2,000-foot setbacks for deep geothermal projects. And with that, that's all I had for you today. I appreciate your time and patience with us. And if you have any questions, happy to address.
Questions? Thank you, Mr. Nguyen. Appreciate you being with us.
Thank you.
We now have Green Latinos.
Good morning, Commissioners.
Good morning.
Would you like to start?
Yes, you can go ahead and get started. We don't see you visualized, but that's okay. We can still hear you.
Yeah, sorry, my internet has been a little wonky, so I'm just going to keep the camera off so it doesn't, hopefully it doesn't lag.
No problem.
So I feel like overall our biggest concerns are that there are the community outreach and the community engagement is not as robust as it has been in the oil and gas space. And frankly, it feels a little disrespectful to the community members that have worked tirelessly, myself included, for almost a decade to build relationships with the commission. And, you know, we fought for all of these community engagement practices, and we've consulted the ECMC with different ways to be a part of that. I mean, frankly, when some commissioners have said that they don't know what environmental justice is, and we're sitting here telling y'all we know what it is, and this is our experience, and that's what we're here for. I think it's really, really important that we don't see these best practices as restrictions, rather as opportunities, because honestly, I'm really hoping that we're able to be proactive instead of having to always be reactive. And then I feel like it was a little confused about one of the recommendations we made to change the or to have the intent of notice sent to other places like schools, or excuse me, in addition to schools, hospitals, you know, physical therapy places, medical places that have been named as places that can ask for a consultation. I feel like it's only makes sense to have the people that are eligible to request a consultation be able to also get noticed when there's going to be a project near them. And, you know, we also wanted to point out that it's kind of shocking that when we had Geothermal Rising talk about how, you know, some of the challenges and some of the impacts that are around this new technology with deep geothermal and enhanced geothermal, we'll need to have special protections for the aquifers, and there's also, you know, some seismicity. And so for me, that's, you know, that's a really big possible impact. And so it's super important. So it's super important to be able to, you know, have protections already in place for community members. And I feel I have a couple minutes, and so I'd like to save those, if that's okay.
Go ahead.
Oh, I said I have a couple minutes left, and so would I be able to save those for the very end, or do I have to use up all my time now?
This is kind of the very end.
Okay, no worries. And then, you know, just overall, when we look at the different pieces of the rulemaking itself, you know, even the Council for Geothermal Rising talked about how, you know, some of these regulations or these reports they're hundreds of pages. And so again, just making recommendations for best practices for community, making the processes more accessible for community members is extremely important. And frankly, you know, with this rulemaking, there was no outreach done in other languages that we saw. And so again, just reiterating the importance of language justice in this space, especially with this new technology. And again, I'll point back to recommendations from NREL. Some of the challenges that they've projected are the opposition for community members, and the best solution for that is to have the community members be able to participate fully. And so also addressing, you know, who are going to be the community groups. We've been in communication with y'all, and, you know, y'all have asked us, who do we need to bring into these conversations? And so I'm not really concerned that we're not going to be able to identify community organizations and community groups that should be involved in this decision-making process. Thank you.
Thank you. Commissioners, questions? All right, thank you again very much for participating with us. We appreciate your perspective. And I believe now we would return back to Mr. Lepore and Mr. Sura, who are both elevated, if they could visualize themselves. You visualize first, Mr. Sura, so you get to go first. How's that?
I did send, hopefully it was received by Mr. Lepore, the language that we were proposing as a compromise solution for this issue.
Mr. Lepore?
Visualize and take off mute. Mr. Chairman, I would kindly, politely, respectfully ask for a few more minutes. I've got some language that I'm asking some people to look at.
Okay. Fair enough. I see that Commissioner Oath has unmuted. Did you have a question, comment, thought?
Well, I was going to say, I actually have a follow-up clarifying questions for ALG, so that could buy these guys some time to go review and discuss.
All right, so we'll give you guys some time. Commissioner Oath, whom from the ALG did you want to speak to?
Mr. Sir, did you have a question first before we?
Yeah, I did. I mean, if there's going to be new language proposed by Mr. Lepore, I'd love to have a chance to see that so we can save time, save all your time. So I have an opportunity to look at it before it goes live.
Yeah, we'll figure all that out. We want you guys to collaborate.
Thank you.
Commissioner Oath, whom am I raising?
I believe that it's Ms. Burke. So it has to do with the piece about the request for an additional 5 business days in a number of cases. And they had 3 citations that I'm finding confusing. So I'd like to walk through and make sure I understand what they're looking for here.
Ms. Burke, did you hear the question?
Unfortunately, thank you. I missed a lot of what Commissioner Oath was saying during my limbo period there.
Sure, no problem. So it has to do with the proposal for 15 business days instead of 10 business days. And you had noted that there were some additional locations in the regulation where that was important. So when I went to go look at those, they didn't quite make sense to me. So I wanted to walk through them with you.
Okay, let me pull up in that case our rule red line. It's probably the easiest way to find it. Okay. So on, let's see, well, the first one was 1302. Okay, 1302C. Changes to approved permits for deep geothermal operations. Is that the one you're looking at?
That is one of them, yeah. So
okay. So operators will file a proposed change to an approved permit, blah, 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 through a Form 4 sundry notice, and the director will review and approve. So Form 4s do not go to local governments. When those are filed, and if someone knows different, but this has been my experience, and we did have some conversation with this, around this with operators and with staff at one point in the oil and gas context. Form 4s, when they're submitted to the director, do not also go to the local government. So we don't have any awareness of when those get filed. The only way we would know is if we spent a lot of time monitoring the filing system of the ECMC, which we honestly can't do, or if by a courtesy, the operator let us know. So
Okay.
if the process is limited to a Form 4, we won't have any indication or any chance to comment.
Okay, I see. So it's not really about other places where there were 10 days of notice and you're asking for 15. It's really about additional areas where local governments would like to have notice.
Correct. So we didn't, yes, I did a search for 15 business days to see where we made that request.
Yeah.
So you're right, we're not changing from 10 to 15. Here, there was no notice. And we did stick in the 15 business days for the reasons we talked about earlier. But
Okay.
yes, it's going from none to some notice.
Okay, all right. That helps me understand where you're coming from. Thank you.
And I'll just triple check. I'm sure that's the same in 1308, which was the other instance. Yeah, same thing.
Okay, thanks.
Okay, you bet.
Commissioner Messner?
Thanks, Mr. Chair. If we're calling back folks to ask questions to, I did have two questions for staff to just better understand intent of their some of the information in the draft rules.
Go ahead. We've got Mr. Boudreau.
Thanks, Mr. Boudreau. So my question, and just to preface, the reason I'm asking these questions and trying to better understand this is, in an attempt to create an efficient process, I'm trying to provide clarity as much as possible, so that, if these things ever do get challenged in front of us, we have certainty as to how to address them. And so one of the things is this equitable compensation piece, and I guess how when it is challenged and gets to us, I mean, how do we clarify that? And so I guess I know that there was a lot of conversation about this at the staff level and developing these. I wonder if you could just provide us a little more detail so that I have a better understanding of how it would get applied.
I think that's an excellent question. And in terms of determining equitable compensation, I think staff recognizes that, especially in the very early stages, it's going to be difficult to do. And trying to imagine what some of the data points might be for determining what is equitable. Off the top of my head, I would expect operators to submit what are the voluntary participants being compensated to be one of the data points for whether or not the inclusion of unleased mineral owners is equitable. If there are any comps nearby, comparable agreements nearby, that would be difficult first if there aren't any nearby in the early stages, or also if they're not publicly available. In terms of geothermal resource units, which include unleased mineral owners being approved administratively, I think, and again, this is just off the top of my head, I can imagine some of those going to hearing, at the early stages, with the commission sort of weighing whatever evidence is presented by the operator and anyone who may have intervened into that hearing, potentially an unleased mineral owner, being able to sort of assess the evidence presented and start to build a body of, let's say, case law for staff to use later on to determine sort of what the equitable compensation standard, like what data points you would want to see for whether or not a proposed equitable compensation plan does achieve equitable compensation. It was intentionally left open-ended, recognizing that in the early stages it'd be difficult to determine. But I believe your direct question is, at hearing, how does the commission assess whether or not the proposed plan is equitable? Is that right?
Yeah, I mean, that's certainly one of the questions I'm trying to noodle on here.
I think that would be a sort of, especially in the early stages, case-by-case determination by the commission, using evidence presented by the parties, and then kind of determining what is the more reliable, what is the reliable evidence there. But I can imagine in the very early stages that would be a very fact-intensive assessment until there's a better idea of sort of what constitutes equitable compensation. It's a dilemma we ran into quite a bit in drafting, because there's just not an established market for what are geothermal resources worth in Colorado.
That's fair. In evaluating kind of voluntary comparisons, is there any benefit in your mind to having 51% versus 45%? I mean, is there any advantage of having a majority of mineral ownership or leased mineral ownership versus something less than a majority, particularly in determining equitable compensation?
I see. So you've got 51% of the geothermal resources voluntarily included, and that gives a little more credence to the suggestion.
Asking the question. I don't know if it does not, but that's just asking the question.
I think it's an interesting point. An extra 6%. I mean, extra 6%. I'm not sure looking at it that way makes a huge difference. And I'm just speaking for myself at this point. Having said that, if you got a majority of the geothermal resources on board, maybe that does lend a little more credence to what their compensation package looks like, and whether or not something similar or equivalent is equitable for unleased mineral owners, unleased geothermal resource owners. Yeah, I mean, I feel like that's definitely a policy call, though. Whether or not 51% somehow makes it more credible, I can see arguments either way.
That's fair. Thanks for your input.
Thank you for your question.
All right, Commissioner Cross.
Thank you, Mr. Chair. And if I could ask two, I think, quick clarifying questions before we have Mr. Sura and Mr. Lepore, that would be helpful. The first, I believe, would be for Ms. Burke, who is elevated. I hope she's still on.
Sorry, I relocated myself, so
No
I am here.
And I just wanted to make sure that I asked a clarifying question, because following up on what Commissioner Oath asked about, and I understand listening to the ALG presentation about there being situations where you would want additional notice, particularly if you're converting a well, and maybe it's not a well that, because of how old it is, local governments may not have had the same kind of input that they previously, or that they have now. My question, as it goes to 1302 and 1308, which were just asked about, is these are talking about situations where this is an approved geothermal permit with some additional changes being made to it. At that point in time, wouldn't we not be talking about the local government siting type issues, but more the downhole issues?
Well, I don't think that's clear from the rules, so, and I would raise something like the Coyote Trail situation with which you are all familiar, where there's an existing operation that either from the operator's point of view hasn't been built out completely, or for example, in Boulder County, we have a lot of older wells that have just been out there for a very long time. And that, so to either add, I would think that adding wells to an existing facility might qualify as those changes. That would be my concern. And then the same with the subsequent operations, that it would actually entail an expansion, but either of footprint or just of intensity. And then also a change of use, you know, for local government, a significant change of use on an existing site is also something of concern. So our proposed language on that we have in our Appendix C to our pre-hearing statement, sorry about that, talks about that the operator must comply with the local regs, which is the bottom line piece. Sorry, try to get out of the dog's way. That must comply with the local government regulations on this change that they're making, but also, and then if there aren't any such, that they would, we would get notice through the, from the operator. Hang on, let me pull up what it exactly says. So our proposed language says, for example, in 1308, I think it's basically the same in the two. The operator will comply with all relevant local government requirements for the conduct of these subsequent operations. If no such local regulations apply, the operator will provide the local government with a copy of the proposed Form 4. So it's an alternative, or a sort of an alternative, I guess you'd say, to making sure that the local government's in the loop.
So if it is purely something downhole and not something changing, expanding, something surface wise that would have that impact, that's where you think the latter part of your proposed change, if it's not something
Yes.
that you regulate, just
Yes.
okay.
Yes, I agree with that. It would only extend to those surface effects and surface uses that we do regulate.
Okay, and I'm sorry, and you said that was Exhibit 6 of your pre-filed, right?
It was Appendix C to our
C.
pre-hearing statement. That's our main rule red line document.
Okay. Thank you. That is helpful. And then I believe that's my only question for you, Ms. Burke.
Okay.
And then if I could, I was going to ask a question of Dr. Jones, and it did look like he may have signed off, and I think it's, if he is not on, it might be helpful to maybe get some input from Mr. Rigby, just sort of a more technical question as some of these issues have come up.
Mr. Lepore, do you still have Dr. Jones?
I'm sorry, Mr. Chair, he is no longer available.
Okay, let's get Rigby visualized. Thanks, Mr. Rigby. Ask your question, Commissioner Cross.
Thank you, Mr. Rigby. And just really quickly, I think one of the things that is helpful for context is there's been a lot of talk about the conversions of wells. 350 Colorado, for example, has talked about some of the integrity issues. Can you give us an idea of the likelihood of a lot of wells being sought for conversion? Do you foresee it being a lot? And if there are sought for conversion, kind of the integrity issues that are rising?
Sure. I wouldn't want to like necessarily diminish the potential, but of the many thousands, maybe, in our report that we put out in July, there was potential, but it requires individual looking at every single well bore. So on the high end of maybe a couple thousand wells are located in areas with usable heat, but there's other factors like is the fluid volume enough? Is the mechanical integrity of the well good enough? Because you're not going to want to, if you're going to have to spend $1 million to remediate a well, then you might just drill a new well, for instance. Also, what's the end use? A lot of power production might want wider well bores and larger flow volumes, depending. That said, there's a lot of potential for sure, but it's a case-by-case situation. Included in our rules is that the operator does need to prove the mechanical integrity of the well for its future use. And that would be on the Form 2 currently. So that would require them doing some testing on the well bore, the cementing and casing, and showing proof that the well bore is capable of being utilized for the new purpose in a safe and effective manner. But to get to like how many, that's going to be determined over time, and I can't really wager much of a guess. And it's going to be very specific to the end use of the project.
Okay, that context is helpful. And thank you, Mr. Chair, for letting me kind of get those clarifications. I just thought it'd be helpful for context.
All right, thanks, Mr. Rigby. Mr. Lepore, Mr. Sura, are you guys ready to talk to us on the final issue?
Do I win?
Yes, you win this time.
Excellent. I'm ready.
Go ahead.
I've shared the language with Mr. Sura. I can't guarantee that he's received it yet, but okay. Let me share my screen. Apparently time for a new computer. Okay.
Would you like me to share it?
I think I'm there, Matt. Thanks. Okay, everybody see it?
Yep.
Again, what I want to be clear is that the well needs to have been low producing or inactive for 3 years prior to the effective date of these rules. Then the operator gets 1 more year. That gives that operator 1 year of notice time, because they've not had any prior to today or prior to the effective date, in which to say to the commission in whatever form that emerges as, hey, this has potential as a geothermal well, therefore used and useful. I think that is eminently fair, and hopefully that's what this language accomplishes.
Care to weigh in, Mr. Sura?
Yeah, thank you. I agree with Mr. Lepore's intent, and I don't follow the language. I think that a cleaner solution is the language that I proffered, but so long as the intent is that there's going to be a year for these operators to determine whether or not that their well can be used for geothermal purposes and to apply under 311, I think that that's right. The language that an oil and gas, a local government can't put forward a 211 request until the well has already been low producing or inactive for 3 or more years. So I think that that's already in the language, and that is implied. And if Mr. Lepore feels like it needs to be explicit, I guess I'd phone a friend and ask for Mr. Boudreau to weigh in whether or not whatever language makes more sense is going to be more easily to follow. I just don't find that this language is very easy to follow.
Okay. I think with that, we have obtained the perspective of both sides here. I don't know that I need anything further from the parties on this point, but I'm just one commissioner. Does any other commissioner need anything further from either of the lawyers here? Seeing shaking of heads in a negative fashion. So thank you both for bearing with us. One final point, Mr. Lepore.
If I may, Chairman, I feel compelled to respond to Ms. Burke's characterization of geothermal rising, advocating for a race to the bottom.
It's okay. I think we've heard enough about that. Thank you.
Thank you.
All right. With that, we are going to halt stakeholder rebuttal, or we will be through with stakeholder rebuttal, and turn it back to commissioners. We're at 11:31 in the morning. We've got the rest of the day set aside for what would now be deliberations. Mr. Boudreau, did you have something to add?
Yes, Mr. Chair, I wanted to give you an update that we heard back from DWR on the language regarding the Southern Ute Indian tribe, and they're okay with the proposed language that we discussed earlier.
Okay, so we've got agreement on the Southern Ute issues on that front. Is that right?
Yes.
Okay, great. Thank you for reminding us about that. Commissioners, what's your preference? Do we want to take an early break for lunch, be able to go back over our notes and then begin deliberations? Do you want to start deliberating now and then break in 30 minutes? I could go either way. Commissioner Messner?
Thanks, Mr. Chair. I would love to take a lunch now, just get a chance to compile my thoughts, and then be prepared to deliberate after lunch. But if we wanted to start, I mean, it doesn't matter, but that would be my preference.
That'd be my preference too. And I frankly have an obligation to go to a different spot. I've got to move into town to my wife's office for the hearings for the afternoon. So if we could take a little more than 30 minutes, that would be great. Maybe it's 11:30. Could we return at 12:45? That's an hour and 15-ish. And that'll accommodate my need to move from one office to another. All right, we're coming back at 12:45. Thanks, everybody. All right, welcome back. This is the Colorado Energy and Conservation Commission. It is Wednesday, August 6th. It is 12:45. We're taking up docket 2405-00115, the deep geothermal rulemaking. We have heard from parties' cases in chief. We've heard rebuttal testimony. We've had extensive questions from commissioners to parties. We've had extensive dialogue with parties on several different areas. This time, commissioners, the floor is turned over to us for deliberations. I would remind folks that we can certainly call people back if need be, including staff. But in large part, I think we're at the place where we need to start thinking about the rules as drafted and any potential edits that the majority of the commissioners think are appropriate. Who wants to jump in? Commissioner Ackerman.
Thank you, Mr. Chair. I'd be happy to lead off on this. And kind of the way that I envision doing this is giving my opinions on the many of the regulatory concepts that were discussed during the hearing at this juncture. And then I certainly have some conclusory deliberative comments, which I'll reserve for later unless we kind of move into the conclusion now. But just wanted to kind of move through my notes, and granted, this will be a little lengthy, and I expect it will all be a little lengthy probably in these discussions, but I'm just going to hit point by point and give my thoughts on each one in a very brief manner, and happy to elaborate and have further discussion on any of these points. Before I do, I just wanted to once again thank everybody for the manner in which these hearings have been conducted so far. I feel like they've been very productive, very professional and well done. And once again, want to thank not just our staff for doing the great work that they've done, but there's a lot of pioneers in geothermal in Colorado. We see some spots throughout the state where people have moved into doing some geothermal work, although it's not deep geothermal yet. and thank the governor for his Heat Beneath Our Feet initiative in helping to really kickstart the legislature into moving through the Geothermal Resources Act and putting us in a position where we can have a chance to make an appreciable difference in the implementation of geothermal and specifically deep geothermal operations in Colorado. I think, we had some conversation about the Reg 1321, the special deep geothermal zones. It seems pretty clear to me that it should probably be removed at this point, and I do think it could use some further evaluation. And as I mentioned earlier in my testimony, would suggest we remand that concept to for inclusion in the geothermal regulatory study, which, as a reminder, is due by the end of this year and is intended to take a look at any of the points that we need to further examine in regulation, and maybe even possibly in legislation or other ways to address that would be appropriate. We had some discussion about the amount of time needed for permit viability, and heard some pretty clear testimony that 3 years would be inadequate for the industry. There was some pleadings for 10 years, and also what seemed to be coalescing upon agreement in 5 years. Seems to me to be the initial sweet spot. I would just remind everybody that my understanding is that that's 5 years from approval of the permit to spud the well. Excuse me. As far as the changes requested by the Southern Ute Indian Tribe, I appreciate the work that was done by staff, particularly Mr. Boudreau and the Southern Ute Tribe. Just wanted to make one comment there that in general, our regulations, in my opinion, should implement specifically their intended purpose, and agree with the AG's excuse me, statement that some of those requests were probably ancillary at most and not appropriate maybe for these rules, but I do appreciate the work that the AG and the Indian Tribe have done to fit those into the purpose of this rulemaking. There was some discussion about reporting mechanisms, allowing more understanding of the impacts of deep geothermal operations. I just wanted to state that I think from my perspective, there is significant reporting required by these draft regulations. They include initial gamma ray, electrical resistivity, neutron density readings, cement bonding reporting, along with mandatory monthly reporting of operations, which will include significant gathering of data, some examples of which would be volume and disposition of fluids, injection, water sources, temperature, surface flow rate readings, among other things. And so I agree with the written regulations on this point and feel that staff has done a good job in setting us in a position where we'll be able to gather significant information about deep geothermal operations. There was also discussion about using electric or cleaner burning rigs to drill, and the same with fracking. We've had similar discussions on the oil and gas front about what should be required and what should not be required. Would point out that AQCC Rule 7 has a nexus with this point, in my opinion, and currently there's also a rulemaking, as was pointed out, at APCD that addresses emissions from fuel combustion equipment. I once again, while we continue as a commission clearly from our history to strive for cleaner burning equipment, I for one don't want to overstep our bounds in emissions into the AQCC and APCD realm, and believe that we should continue to encourage best management practices, but not necessarily mandate a certain form of rig. Excuse me. There was a discussion about not limiting community liaison work to oil and gas. And I think that has some merit. I'm in the camp of, for now, I think that we don't extend that to the geothermal realm. It was intended for oil and gas. I would be in favor, though, of revisiting that concept or a similar concept once deep geothermal operations proliferates to a commercial viability status. And once again, would, excuse me, remand that to the study. There was a request to extend public comment periods to 60 days. And while I understand the industry prefers rapid permit issuance, I do think public comment on the front end makes for better, smoother project on the back end, and would be in favor of a 60-day public comment period in the instances in which it was requested, which I believe was in disproportionately impacted communities. And I can be corrected if I'm wrong there. I'm generally supportive of all the requested public notifications, but not necessarily supportive of extended consultation other than what I just mentioned at this point. Once again, I believe we can revisit this as geothermal proliferates into commercial viability, and we do happen to see geothermal operations being requested, beyond which initially will likely be a very pilot type approach. Once again, I do think remanding other public process additions for future consideration would be reasonable. I'm not sure that they would be ripe in time for the study to address that point. So I do think that we should keep in mind, as we always do, what public processes should look like with regard to deep geothermal as it moves through its life cycle. There was a request on pooling to set up a working group to formulate how to handle geothermal resource units or pooling. I keep talking about the regulatory study. I think the regulatory study is a built-in approach to address and recommend issues that need further examination. At this point, I wouldn't suggest working groups for geothermal issues, at least prior to the study and the ensuing processes that are likely to stem from that study. That said, the percentages for pooling have been significantly debated and resolved with regard to oil and gas. As severance of geothermal from surface ownership is virtually, or maybe even literally non-existent, I would expect a much less complicated scenario in most cases with regard to surface owners on geothermal projects. And I am supportive of moving forward with the 45% standard as debated and established by the legislature. Was requested again, better notice to resource owners. And like I mentioned, I generally support all notifications. I agree that it would be, as I just mentioned, exceedingly rare to have geothermal resources severed from the surface, but and so I'm okay with surface ownership notifications being the focus of those notifications. We didn't talk about this much, but a timing issue came up that pooling was allowed after drilling. I certainly, as one commissioner, could use some further information on this, further discussion and analysis and evaluation of what the implications are of that and what we would be needing to solve associated with that. I do think this is another issue that could be remanded to the study and expanded on. I do think, we're going to have some one-off development once again with pilot projects in the initial stages, and do think we have some time, certainly prior to more standard applications and drilling of deep geothermal resources. Same goes for me with regard to undefined cost recovery and equitable compensation. I think this is a very important issue. I certainly could use further information on this. I think we need to have significant further detailed examination of this issue. But once again, I think we need to do this most importantly prior to rolling out commercialized geothermal energy production, and not necessarily prior to pilot projects, which, as I mentioned, are likely to be kind of more one-off situations. And as you can see as my trend, this is another issue I think would be important to take a look at or include for examination in the study. There was a request to exempt local government resources from non-consensual pooling. I would not include this in the regulations. Local governments, as we've talked about a number of times, have significant local control of geothermal development. And I would also note that there's no rule in the draft exempting state lands either from non-consensual pooling or of geothermal. There were a few cleanups: working pad surface, geothermal pad surface, a couple other cleanups, a typo. I just wanted to note that certainly it stands to reason that we would address those. On the point of converting oil and gas well bores, I do think that this is a whole-scale change in use and should be subject to notice and permitting requirements. And I agree that I think our regs do this pretty well through requiring a new permitting process through a Form 2 for complete conversions. And certainly I'm open to notification processes surrounding that Form 2, but I do think a Form 2G full process from the beginning is probably an overreach, as many surface issues were likely addressed already. And in in all honesty, probably any surface changes associated with geothermal conversion are likely to be what most people would consider favorable. Some significant discussion about certain circumstances that warrant commission hearings, either mandatorily or requested by certain parties. And I kind of coalesced around this a little bit where Mr. Sura did, as far as requested pursuant to 507 by any party entitled to consultation. I think if we go down that road, that's the most prudent place to go down. I would, however, continue to, at this point, once again, leave this to director discretion. I think the point was well made by Mr. Sura. And this is an issue that's likely to be much more applicable and timely once deep geothermal operations proliferate beyond the pilot stage. And so this is another issue, to be clear, that I would remand to the study. 350 Colorado asked a couple of times, reiterated that they would wish that we would indicate in the basis and purpose statement of a commitment to a second rulemaking. I don't know that we can specifically commit to a second rulemaking, as we don't know what rules we would address and if we would need to address rules. I do highly suspect that we may need to have a follow-up rulemaking at some point, pursuant to the study or of our own volition. I would be in favor of mentioning the regulatory study in the statement of basis and purpose, and conceding that that certainly may lead to subsequent rulemakings. The point of wells that frack keeping the 2,000-foot setback, and I'll address the 2,000-foot setback in general. I'm not in favor of starting this way. Again, I would rely on local governments who would prefer a larger setback. They have more than enough authority to do so, and I would leave leeway for those, as was testified by the Western and local rural governments. I said that wrong. That they would not wish to at this point. It seems most prudent to me to once again at least start with not without a 2,000-foot setback, and certainly look to local governments that were interested in creating setbacks and working together with them in the application processes. I'm in favor of protecting the community and reducing the cumulative impacts through notice and the educational materials that was requested, and do think that we should, whether it's necessary in regulation, we should certainly encourage as a permitting procedure the dissemination of proper notice and educational materials, particularly since this is a new technology and one that the great majority of Coloradans likely have some degree of slight familiarity with, but probably not much beyond that. I am not in favor of applying cumulative impacts analysis to geothermal rules at this point. We were not directed to do so by the legislature, specifically at a time when cumulative impacts was prominent. I believe this was intentional and intended to help us streamline this process at the onset and get geothermal off the ground. I don't think it's prudent to do so at this point. I would not expect significant cumulative impacts additions from deep geothermal operations for quite some time to come. We were asked for rules to monitor and protect leakage. There are good protections in place in these draft regulations. I don't think methane leakage is expected to be a common issue with geothermal wells. I'm willing to recommend this issue for consideration in the regulatory study, but really just specifically with regard to the conversion of oil and gas wells to deep geothermal wells. And I think then wellbore integrity rules are in place, as mentioned by Mr. Rigby, and we have significant protections and monitoring with regard to this issue. With regard to the issue of the director deferring to the relevant local government site disposition instead of considering, I would agree with the allied local governments. I don't think we should subordinate on specific points to each other in this way. I prefer consider when we're talking about the state permit. And I don't think the intent is to subordinate this commission's decision-making to the local government decision-making or vice versa. So I would be okay with strongly consider or some other elaboration short of complete deference. Mineral owners notice, the Colorado Oil and Gas Association and API brought up the point of when you're exploring for geothermal, you may have some conflict or potential for conflict with other minerals owners. To me, it would make some sense to provide notice as requested to owners of all minerals in the operation location. I think we would need to have further conversation about how that's researched, how that data is obtained by a geothermal company who's likely not very plugged into other types of minerals. So I would believe we would need some further discussion on that point. And those were all my specific notes, Mr. Chair, at this point. I tried to be as concise and clear as I could on those regulations. Certainly have some more general comments about this rulemaking and some other thoughts as we move forward.
Thank you very much, Commissioner Ackerman. Again, I want to thank you for sort of leading the commission on this rulemaking. Excellent work by you, staff, and all the stakeholders, and really appreciate you going through a lengthy list of various areas with some ideas about approaches. Maybe we can just go through that list as well, and see with regard to other commissioners, are there things, number one, not on the list that need to be on the list? And then maybe we could, and I've typed it all up, and I'm sure Commissioner Ackerman has it typed up as well. But that would be number one. Are there anything missing? And then number two, we could start to get some sense of whether we've got consensus around the list of issues that need to be deliberated upon. Commissioner Messner raised his hand.
Thanks, Mr. Chair. I didn't totally organize my thoughts that way. It might be a little hard. I mean, I can kind of do what Commissioner Ackerman did and share my general sentiments on the different areas, but I might be jumping back and forth if I'm following Commissioner Ackerman's list. So what would you prefer? Do you want me to just—
I think what I would prefer is, I mean, I think it might be easier if we go with Commissioner Ackerman's list in terms of like walking through it and seeing where people are on each of the issues. But I think what we need to do next, and I'm just one vote here, but maybe if we see if there are things that are not on Commissioner Ackerman's list that are important for folks to talk about, we could add it to the list. And then again, I've typed it up. I can then walk back through, like the first one was deletion of 1321. The second one was permit timeframe. The third one was tribal changes. So, I mean, that's just me throwing out a proposal. Suppose we try to add to the list, and then we could go back through. I would also encourage Benjamin Bedreau, our AG, to find his way to the panel. I have an idea as well in terms of like how we move from this to next steps. Is he with us? Well, let's let him find his way back to the panel. Oh, there he is. AAG Bedreau, knowing we're still kind of early on in this stage, if we proceed down this path, add to the list, and then, take little votes like, okay, it's 3-2 on permit years, and I'm just making it up. Could you kind of keep track? And what I'm wondering is, we have this set up for a hearing on Thursday. It might give you and staff an opportunity to kind of clean up a final draft and then present that back to us on Thursday. And again, commissioners, I'm not trying to dictate how we're doing this. I'm just trying to look at perceived paths forward. But AG Bedreau, is that something that could be doable, do you think?
Yeah, staff and I can work in your revisions or your direction on what to change, and then get you back a copy of it, say maybe Thursday morning, or anyway, we'll try to get it to you as quickly as we can. And then, yeah, we're already scheduled on Thursday, so I think that plan works for staff.
All right. Well, again, it's just an idea, a concept. Having heard on all that, Commissioner Messner, what are your thoughts? or Commissioner Oath, Commissioner Cross?
Yeah, I mean, I'm curious to hear other commissioners' thoughts. I mean, again, I didn't craft my thoughts that way. I mean, I crafted them a different way that kind of, well, what I usually do, which is, you know, a discussion on like the lens that I'm viewing this through so that folks can understand how I'm approaching this. And then, you know, my thoughts on the draft, and then my thoughts on any additions or deletions from the draft based on party presentations. So I think it's important for me to be able to
go ahead, John.
The basics of it, just because I
do your thing.
I'm just trying to like make my record, right? As I've been directed by the AAGs. So, okay, I'm just gonna roll, and then you can pull off of it and apply it to Commissioner Ackerman's thing as you see fit. But you know, number one, I do think deep geothermal is an exciting opportunity for the state of Colorado, and really do, as Commissioner Ackerman indicated, you know, appreciate staff's effort in developing the information necessary to develop a thorough set of draft rules that balances both the agency's statutory requirement to permit geothermal in a way that ensures, you know, the protection of public health, safety, welfare, the environment, and wildlife resources, with creating an efficient permitting process that jumpstarts the development and encourages investment in geothermal operations in Colorado. I also appreciate all of the thoughts, effort, and input from the parties in this rulemaking. Developing rules that take into consideration all of the different perspectives of stakeholders across the state is indeed the Colorado way, and it is something that I'm very proud of. As I reviewed the rules and the parties' pre-hearing statements and hearing testimony, I viewed it first through the lens of our statutory direction, as we are an agency who derives its authority and direction from statute. First, the legislation declaration provides the purpose of developing the rules. It indicates the development of geothermal resources is in the public interest because it enhances local economies and provides an alternative to conventional fuel sources. And the development of geothermal resources should be undertaken in such a manner as to safeguard life, health, property, public welfare, the environment, and wildlife resources, encourage the maximum economic recovery of each resource and prevent its waste, and protect correlative rights. And second, the statute provides the bookends of what, in my opinion, we should be considering in this rulemaking. On page 10 of the Act of Senate Bill 23-285, it states, in exercising its regulatory authority pursuant to subsection 1B of this section, the Commission shall adopt rules that protect public health, safety, and welfare, including the protection of the environment and wildlife resources, and avoid, minimize, or mitigate adverse impacts on disproportionately impacted communities. It goes on to say that the Commission shall not issue an operations permit pursuant to subsection 1B2 of this section unless the applicant provides evidence to the Commission that the applicant has filed an application with the local government with jurisdiction to approve the siting of the proposed deep geothermal operations, including the local government's disposition of the application, or the local government with jurisdiction to approve the siting of the proposed deep geothermal operations does not regulate the siting of deep geothermal operations. Again, I cite the act because I do believe that this agency and this commission gets its authority from statute. It is my goal to promulgate rules that meet our obligations under statute and in turn develop a functional regulatory structure void of areas of conflict or miscommunication that would create an inefficient permitting process. Efficient permitting processes clearly lay out the requirements and expectations for application submittals, set up opportunities for consultation and feedback to applications, and provide notice and communication to any applicable, relevant, or proximate person or entity to ensure transparency and minimizes potential unknown conflicts, and finally, a review process that clearly applies the rules that have been promulgated. The primary factor in ensuring an efficient permitting process is the quality of the application received from the applicant, with all of the required elements being submitted with enough information, commitments, and detail to meet the performance-based and prescriptive-based requirements of the rules. I believe the framework set up in the rules creates an efficient permitting process, which, as indicated by the testimony of Geothermal Rising and other industry advocates, is essential to encourage and even jumpstart geothermal development in the state. I also think the rules as proposed are protective, as is required by statute. I also think the rules memorializes the local government's authority in permitting the siting of deep geothermal activities, which is a keystone of land use planning in the state of Colorado. And finally, as required by statute, I think the rules provide provisions for avoiding, minimizing, and mitigating impacts within disproportionately impacted communities. Having said all of this, I think a couple of adjustments should be considered based on submittals and testimony by parties in this rulemaking. Number one, it's clear in statute that it is intended that the state and local government processes communicate with one another. This is important for a number of factors, but first, it is well established that local governments have land use siting authority within its jurisdictions, and for an operator to be able to develop geothermal resources in any given area, it must get both a local government permit as well as a state permit. Clear coordination and communication between the state and local governments will help facilitate an efficient and certain permitting process for geothermal operations, which is a stated goal of industry. With this in mind, I do believe the suggestions of Adams County and others to ensure notice for elements of proposed rules 302C, 1305, 1302C, 1305D and E, 1308, and 1311. In addition, in Rule 1303F regarding local government's consultation, it should be required that the director consult with the relevant local government for every application and the proximate local government in situations where the location is within 2,000 feet of the jurisdictional boundary. I don't know if it's necessary to have prescriptive elements as to what needs to be included in the local government consultation, as the local government can bring up any relevant information to the consultation they deem necessary. Again, these notice and consultation requirements will aid in a more efficient permitting process by increasing communication and coordination between permitting entities. Number two, surface use agreements for new and existing wells need to stay in the rules as drafted as agreed to by Geothermal Rising. Number three, for Rule 1305E4, I think that giving the director discretion and flexibility to determine what they think may be appropriate for pushing an application to the commission for hearing is appropriate. I would note that the commission itself also has discretion and flexibility in determining what may need to come to the commission for hearing on its own motion. So rather than put prescriptions within the rules, I would like to see some discussion within the statement of basis and purpose for situations that may cause the commission to want to have a hearing to provide some additional context and minimize challenges. Challenges cause an inefficient permitting process. Number four, in Rule 1311F, converting oil and gas wells to geothermal should require a 2G to clarify operations. And I say 2G, I'm open to an equivalency, but the important thing is to clarify the operations, address adverse impacts, and ultimately minimize challenges and increase efficiency. In Rule 1320, it should include Mr. Sura's updated language regarding the timing of Rule 211 hearing applications as it applies to geothermal well designation. This is to minimize potential abuse of this provision, which I am concerned about, and increase efficiency of permitting processes. We need to be careful to not make adjustments to well-established and vetted oil and gas rules around Rule 211 unintentionally within a geothermal rulemaking. Number six, statute requires this commission in its rulemaking to avoid, minimize, and mitigate adverse impacts on disproportionately impacted communities. In addition to it being required in the act and therefore an enforceable requirement of applicants, there are rules included in the draft that address this topic, including requirements in the Form 2G submittal per Rule 304B7J, which is an oil and gas rule, which states if the proposed deep geothermal location is within 2,000 feet of a residential building unit, high occupancy building unit, or school facility located within a disproportionately impacted community, the applicant will comply with Rule 304.20B and C, which are oil and gas rules, providing a community outreach plan, and secondly, include a proposed plan for how the deep geothermal operator will avoid, minimize, or mitigate adverse impacts of drilling and production operations on the disproportionately impacted community. By applying the mitigation hierarchy and requiring an operator to make a showing on how they will avoid, minimize, and mitigate adverse impacts of drilling and production operations upon the disproportionately impacted community, the applicant will necessarily need to contemplate siting, cumulative impacts, environmental justice, emissions, noise, odor, lighting, community outreach, and other considerations brought up in submittals and testimony, and other considerations that were brought up in submittals and testimony provided by the Green Latinos and others. Utilization of the community liaison in these community outreach efforts, to me, only makes sense. Details as to what needs to be incorporated in a community outreach plan are extensive and are defined in the existing rules, and are the same requirements that would apply to oil and gas operations. I would also note that the just transition testimony provided by Geothermal Rising, to me, is compelling and is a potentially beneficial component to addressing adverse impacts to disproportionately impacted communities, many of which are located on the western slope as defined by statute. Number 7, I think applying the setback requirements associated with oil and gas development to geothermal development are not reasonable or necessary, as unlike oil and gas development, the long-term direct benefits associated with geothermal development, and in some cases, the need to site locations in proximity to end users of these direct benefits, have the potential to outweigh the short-term impacts associated with the development of these resources. That is not to say that the proposed development should not be ensured to avoid, minimize, and mitigate potential adverse impacts. We are statutorily required to obligated to require that, but that depending on the technology proposed and the end user of the energy, flexibility in siting seems reasonable. Local governments may see this differently, and they have the ability to determine different siting requirements within their processes. Number 8, I do think some consideration for utilizing the best available technology when it comes to drilling and potential completion activities in the ozone non-attainment area should be considered. In conversations I have had with geothermal operators from around the world, it is rare that drilling operations are done with something other than grid power. I do not see a need for prescription on this point, mostly because at this point, the number of actual operations is most likely to be so limited as to not be reasonable and necessary to require it. However, some language in the statement of basis and purpose that encourages operator to utilize the best available technology is certainly warranted. Number 9, I do think future rulemakings on this topic are to be expected. The commission at any time can determine it needs to hold a rulemaking, and I think allowing the commission the flexibility to determine the timing and topic of any subsequent rulemakings is appropriate as we see how deep geothermal development evolves in Colorado. And number 10, finally, I think the revision of a 5-year expiration date on the permit application strikes a reasonable balance between the need to have certainty as to the timing of operations, so the evaluation and communication regarding potential impacts can be determined, and the need for operational flexibility for the applicant to develop the proposed location. In conclusion, I feel these minor revisions and clarifications to the draft rules are reasonable and necessary to first meet this commission's statutory obligations as explained earlier, and secondly, to promote an efficient permitting process through clear communication, transparency, and coordination between the applicant and the applicable reviewing bodies, which helps provide clarity, efficiency, and certainty, which has been expressed as essential to jumpstarting this type of energy development in Colorado. I do think there are a couple of unresolved topics on my mind, particularly the issue of equitable compensation and mineral ownership requirements. Certainly open to other commissioner thoughts on the topic. At this point, I'm inclined to leave the draft as it is, understanding the potential for inefficiency should there be challenges on these topics, but also like Commissioner Ackerman's thoughts as far as having that as part of the study. So those are my thoughts, at least the way that I had them structured in my brain. Thanks, Mr. Chair.
Thank you. I'm still inclined to go back to Ackerman's list at some point in time. I think it's easier for my staff to be able to figure out how to adjust this. Commissioner Cross, Commissioner Oath, do you want to provide perspective? Commissioner Cross?
Thank you, Mr. Chair. And I'll admit I had also kind of organized, not necessarily point by point, as Commissioner Ackerman did, but kind of some of the key points that came up to me. However, I'm happy to also go through the list that Commissioner Ackerman provided as well. And I think that one thing that was not, in terms of your question from before, I think one thing that was not specifically addressed by Commissioner Ackerman, which I believe was unintentional, and was the 211 issue that was talked about between Mr. Sura and Mr. Lepore. And so that, I think, is the one additional thing that I had in my notes as to what to include.
Okay. So why don't we do this? I'll add that to the list, but then go ahead and do your deliberation like Commissioner Messner did, and then we'll try to sort of tally it all up once everybody's had a chance to weigh in, if that works for everybody.
It does, and with that in mind, I think it's probably best for me to kind of truncate some of my notes here to talk about some of the issues as they've been brought up a little bit, and I think it doesn't need full resuscitation on some of the issues that have already been discussed. I'll start with just the Southern Ute Indian Tribe information. I think the agreement that was reached is appropriate. I'll say, I think, to me, probably one of the biggest things that jumped out and what we heard in testimony is the idea of notice, and also the comparison of notice versus consultation. And I think, especially looking back on some of the meetings that we had and some of the listening sessions we've had on other potential rulemakings and other rulemakings and meetings, is I think the importance of transparency is something that the people of Colorado have repeatedly indicated that they want, and transparency, I think, is an important thing for us to have. And therefore, I do think that some of the requested notice is appropriate. That said, I'm not sure that consultation is necessarily appropriate for, and that's one of the reasons why, especially with the allied local governments, I tried to probe a little bit the idea of, do they need the consultation, or is it more so a notice of what's happening so they do have the opportunity to comment? And I appreciate the dialogue on that point. And I do think that having notice and being given the opportunity to provide comments is a good compromise to make sure that we keep this an efficient process, while making sure that that transparency and the ability to participate and ability to sway decisions as necessary is done. I think within that, there was also some discussion as to notice, and I know it was brought up as a consultation with community organization-based groups. And again, I think that the notice to these groups is important. And as was discussed in some of the discussions back and forth, I do think that this is something that we need to probably delve a little bit more into. I appreciate Ms. Garcia Nelson's and Mr. Tafoya's ideas, and Commissioner Oath following up on it again today. The idea of using our community liaison that we're working on, getting up and going to make sure that we identify the appropriate groups. But I do think that if we're going to have something in our rules talking about this, I do think we do need some further definition. And part of the reason I have a concern over this is I don't want to necessarily say, oh, well, here's an organization that sort of says that they represent everybody. And so that might be somebody identified by the community liaison saying, I talk to this group a lot, but are they kind of representing everybody in the state, everybody in the non-attainment zone? Are they representing everybody on the West Slope? And I think in a lot of these situations, it's going to be more important to kind of really drill down on the area who's specifically going to be impacted in this. And so as opposed to looking at a much broader area, I think it's important to focus on trying to come to an understanding of what a community-based organization is and kind of the breadth of what we're going to be considering for that. And so I do think that that's something that I'd like to continue to work with not only our future community liaisons, but also with groups such as the Green Latinos, and making sure that we can find an appropriate way to do that and really identify the best people that we can talk to so we do get that transparency in our process, while again, making sure that we make this an efficient process in terms of encouraging geothermal, deep geothermal operations in the state of Colorado. The next point that I had some notes on was the 51% versus the 45%. And this was touched on by Commissioner Ackerman as well. And I think, to me, the important aspect is the legislature this year did talk about the idea of changing that percentage. And despite that being brought up in the legislative session this year, it was not changed to 51%. And so to me, I foresee this issue being kind of usurping what the legislature can and should do. And the fact that the legislature did not change this indicates to me that this is something that we should not be trying to change, given that the legislature had the opportunity to do so. So I'd be in favor of keeping this at 45%, consistent with what the legislature has done to date. I know both Commissioner Ackerman and Commissioner Messner did talk about the setbacks, and I agree. As Commissioner Messner said, I don't think it's reasonable or necessary at this point in time to have a 2,000-foot setback. Many of the indications are there could be benefits that would need this to be closer, especially depending on the end use of a geothermal operation. Additionally, I think that the key to me is that the fact that local governments are also getting a say in this process. So as both my fellow commissioners mentioned, the fact that local government can say, in this situation, we do want to make sure that this is at least 2,000 feet from any RVU, any school, whatever the case may be. I think that they have that participation in the process. And so I think that given that, we don't need to be prescriptive in a 2,000-foot setback to make, I don't think we need that in our rules at this time. The specific equipment, again, I agree. I don't think that we need to have any kind of prescriptive equipment listed in our rules. And to me, I want to go into a little bit more depth than was brought in before. I think is if we start to say, to make sure that emissions are lowered, to make sure emissions are minimized, reduced, you need to use certain equipment, in my mind, starts to usurp our jurisdictional authority and start to go into what CDPHE regulates and say, you have to use this equipment to make sure that this is done. I don't think we have the authority to do that. I do think that we have the authority to make sure that operations, whether it's oil and gas, whether it's CCS, whether it's geothermal, we have to make sure that it is, sorry, I just looked like my computer froze. I'm sorry if everybody lost me there for a minute. I do think we have the mandate to make sure that we avoid, minimize, mitigate adverse impacts. And I do think we have the legislative mandate to make sure that we regulate in a manner that's protective of public health, welfare, safety, environment, and wildlife resources. In that, I believe that having best management practices, as we do with the oil and gas process now, but not mandating that certain equipment be used, is the best way we can do that. I think it's important for the public to know that this is not simply getting a rubber stamp from the director in these situations. We are, and I'll bring up some of these points later, but we are going to make sure that there are mechanical integrity tests. We are going to make sure that the 2G is going to go through and make sure that different aspects have been evaluated to make sure you're not going to be impacting wildlife. You're going to be consulting with CDPHE. You're going to be consulting with the Division of Water Resources. You're going to be talking with these different groups and making sure that what's ultimately put forward is protective. And so I don't think we need to take that extra step of trying to prescribe certain equipment, especially where, as I said, I believe that that's stepping over our jurisdictional boundaries there. With respect to 211, I do appreciate the dialogue back and forth between the parties on this. I do think that the language shared between Mr. Sura and Mr. Lepore, I think, has put us in a good place. As Commissioner Messner said, I don't want to try and impact the 211 process inadvertently through what we're trying to do here in the geothermal rulemaking. And I do think that what has been discussed and what has been put forward, I think, is probably a reasonable way to kind of match what both sides have presented as issues here. We do want to provide the appropriate notice, but we also don't want to delay this out for an exceptionally long time as a way to try and thwart the rules. With respect to the expiration issues under 1307, I'd like to hear some more discussion on this. I agree that I think the 5 years is kind of splitting the baby in something more appropriate, but I would like to hear more from my fellow commissioners as to, as Commissioner Ackerman said, is this going to be the date of spudding? Are we going to have any kind of expiration after spudding to make sure that it's been done? Are we going to, or at least some kind of expansion of what's been planned to avoid more coyote trails type issues? Is it going to be completing what's required under the application with 5 years? I think it's probably appropriate for us to delve into that issue a little bit further. Like Commissioner Ackerman, I do think that 5 years to spud is an appropriate time frame, but I'd be curious to know what my fellow commissioners think about timeframes of finishing after the spudding to make sure that this isn't an ongoing process that brings apart issues that we've seen in oil and gas situations. With respect to the entitlement to hearings, I'll be honest, I think this is one that I do have concerns over. I do think it's important to make sure that everyone does have the opportunity to participate in this process. And that's why I thought it was important to talk about the notice and the consultation issue up front. I think that one of the key things to me is if we do expand on the notice part of what we're discussing and what has been put in the draft rules, I do think that that can alleviate some concerns. We do have the opportunity to make sure that this is brought to a hearing. The director has the opportunity to make sure that this is raised to our level at the commission as well. And I just worry that we're going to hinder that efficiency that we're trying to have the appropriate balance here. If we start saying, we're providing notice to this group wants to say something. This surface owner, one surface owner out of 50 has an issue and therefore they want to bring it up to a hearing. I think that as long as there's the opportunity to provide the public comment, we will be able to say, this is appropriate for us as a commission to raise a hearing on this issue. And so I think that just automatically saying that we should be able to, anyone should be able to request a hearing is probably a step too far, especially as we're, again, as Commissioner Ackerman noted several times, especially as we're just really kind of getting into the start of geothermal operations in the state. This may be something that we want to look at in the future after we start to get more commercialized operations. And then the last thing that I had in my notes that I initially put together was with respect to the mechanical integrity issues that were raised by 350 Colorado. I did get some clarification on what was really being looked for. And that's specifically about making sure that the language that you have to demonstrate the wellbore integrity for converted wells with appropriate logging and or mechanical testing as approved by the director. I think is one of the concerns that 350 had. And I think that we can clean that language up. We do have the appropriate regulations in there now to require the same mechanical integrity testing, the same Braden head testing that we do for oil and gas wells. And so perhaps we can rework that language to make sure that it doesn't sound like when you're converting a well, the director can just approve any kind of mechanical integrity that seems appropriate, it has to go through the mechanical integrity test that we already have. With respect to the idea of requiring quarterly mechanical integrity tests, I think that's superfluous. Where we're looking at mechanical integrity tests now is shut-in wells, wells that are not complete, drilled but not completed, pre and post fracking. You're looking at a lot of these issues to make sure that what has been done has mechanical integrity, and you do have the occasional checks to make sure that that mechanical integrity hasn't changed. I think one of the things that's important for the public to know as well is there are a lot of sensors, there are a lot of monitors on all of these wells now to make sure that if pressures are changing, we are able to detect leaks. And that's why a lot of the operators now have the automatic shutting capabilities, they have the remote sensing capabilities. And that's the kind of thing that avoids the need for continuous braid and head testing, continuous mechanical integrity testing. And at this point in time, I don't see the need for an expansion on what we already do with oil and gas, especially to the level of quarterly mechanical integrity tests. So those are the kind of the points that I had set aside to talk about as my key points beyond the list. And again, I think I'll leave it there for now and get and hope to get thoughts from Commissioner Oath and Chair Robbins before we kind of talk about the list that's been put forward as well. But as noted, I think the 211 was the only additional thing that I did not hear about that was not included in that list.
In my notes, Commissioner Cross, is that you're in favor of the language developed up by Miss Attorneys Lepore and Sura on that front?
Yes.
Okay. Commissioner Oath, do you want to provide some commentary?
I would love to. Want to start by expressing my appreciation for this process. It's been quite an interesting and exciting, maybe historic and certainly very memorable first rulemaking hearing with this commission on my third and fourth day in this role. You know, just the level of information, the amount of questions, the thoughtfulness that has gone into this is very much appreciated. So thank you to everyone who has been participating. I have some targeted thoughts, and actually my list, I think, very closely matches Commissioner Ackerman's list. They may not be in the same order. So for that, I am sympathetic to our staff. I have been in their shoes many times trying to track commissioner positions during deliberations. So I will try to go at a speed where they're able to kind of mix and match the order in which we talk about these issues. But I do think they largely match. So we're in good shape there. I will not go into great depth on some of these issues because I think we're starting to coalesce around some positions on some of the larger areas that have been discussed throughout the hearing. So for example, with respect to the section on the special zones, agreed that, you know, the idea has a lot of merit. I'm glad that it was considered, developed a bit, and think that it will benefit from further development and discussion in the future, but is probably not ready to be included at this time. I, for many of the reasons that have already been stated, also agree that I don't think that it would be appropriate or necessary to add requirements for cumulative impact analysis, alternative location assessment, or the 2,000-foot setback at this time. I think the relative risk of deep geothermal development is just very different than oil and gas once we're past the pre-production phase. And I did not see studies to support the need for setbacks or other requirements of this nature at this time. On the topic of commission hearings and, you know, when those should be required, I am persuaded that at this point it makes the most sense to keep this at the discretion of the director. An idea that I have to keep our arms around this as we move forward is perhaps to add some statement of basis and purpose language that would ask for the director to kind of report back to this commission on a regular basis, maybe annually, to just kind of give us a sense of what are the permits that have been received and acted upon by the director, so we can see if we're in agreement about the types of applications that are being handled administratively versus those that, you know, we think may be appropriate to come to the commission for a full hearing. And then over time identify, you know, when we may get to that point where we have a sense of what are the types of factors that would trigger a hearing. So we could then, you know, move forward with a rulemaking hearing to develop some rules that will therefore create some certainty for operators and others, right? I think we're trying to balance the efficiency here, but also certainty for operators is really important as well. And so when we have a sense of what are the types of things that would trigger a hearing and add on some time, it would be good to clarify that in the rules. With respect to, you know, whether or not to, how to address maybe some interest by entities that are consulted, such as schools or local governments, you know, should they have the ability to request a hearing, you know, when we could, you know, ask that the director include in this report information about concerns that were raised by, you know, entities that were consulted, that if those concerns were not addressed throughout the administrative hearing process. So that's that issue. On the issue of whether or not to include explicit language about having a second rulemaking hearing. I agree with other commissioners. Certainly, this is going to be an iterative process. I would absolutely anticipate that there will be a need to update our rules over time. And I, you know, but I do expect that that the first step will probably follow the study that is, you know, coming out in just a few short months. And so I don't think that it is appropriate to prescribe now what the timeline of a second rulemaking hearing would be or what the scope of that would be. I think it's better for us to retain some flexibility. And also, I think I'm always hesitant to bind future commissions to specific actions. With respect to conversation around how best to ensure that community members are aware of and have opportunity to participate in the process, this is, I think, a very important issue. I appreciated the suggestions by Green Latinos and others in this respect. I did, I think, share during the Q&A my idea, and I think I'm still in that same place. Would love to at least see our staff try to take a shot at putting this into regulatory language so we can react to that and see if it works. I would love to see where they think it makes the most sense. One idea could be in 1304D, which is the section about consultation with schools, childcare centers, and school governing bodies. It could be expanded to include community-based organizations in the title, but then the subsections would need to be worked a bit, because I think in my concept or my thinking, the idea is that if the development is going to occur, you know, within 2,000 feet of, you know, an RBU, high occupancy building or a school, and is in a disproportionately impacted community, then I'd like to see the operator consult with the community liaison, who can then you know, convey to the operator whether or not there is a relevant community-based organization in the area and provide some contact information. And I would agree with Commissioner Cross that for me, this is about notice, not necessarily consultation. So I appreciate ALG pointing us to their Exhibit 1, but in my mind that really was about requiring consultation with the community-based organization. And my idea here is a bit different, which is about ensuring that we're providing notice to community members, and really have found that, you know, providing that notice through community-based organization is a best practice in this space. And so want to see us explore that. I also am sympathetic to the proposal to allow some additional time for comment, and so would be supportive of in 1305 D1A changing the amount of notice for public comment to 60 days instead of 45 days for facilities within 2,000 feet of RBUs, high occupancy buildings, or schools in disproportionately impacted communities. And then finally on this point, with respect to educational materials, I appreciated this discussion. I think it was a good idea by 350 Colorado, appreciated Geothermal Rising's kind of response here, agreeing that, education is really helpful for folks to really understand what geothermal is, what it is not, and that they have an opportunity to engage. It does sound like the State Energy Office and others may already be developing some educational materials. And so I think there is some question in my mind, who's the right entity with the ability to be doing the education and developing educational materials. So I would stop short of requiring an operator to provide educational materials in these instances, but would like to see the regulation encourage the operator to include educational materials, and think I heard a similar thing in Commissioner Ackerman's list. I don't know if this one was in Commissioner Ackerman's list, but I did hear some testimony about 1304A from the local governments, indicating that if the intent was that the pre-application consultation includes local governments, that's not clear in the regulation. I think the intent is that, and I would agree that some clarification to that language would be helpful. Let's see. The life of the in 1307, the life of the permit, I also felt like 5 years seemed like an appropriate place to land here. If we're getting into the details of to spud, I think is what Commissioner Cross said. Again, this is my 4th day. I will benefit from additional discussion on some of those details of the options here and what we're meaning by that. The Southern Ute Indian tribe, I am supportive of the language that the tribe and the staff were able to come up with. I think one item that was not on Commissioner Ackerman's list had to do with GeoX's proposal in section 1312 to allow the use of wastewater, so including produced water and treated sewage, without having to get prior approval from the director. I was not persuaded and did not find there to be sufficient evidence on the record that this has been vetted. So I would like to keep that as it is. So I don't think that we need to add that to the list for discussion unless others felt differently, but it was just something I noted. Monitoring was something that I was very interested in the testimony about. I do find that as was outlined by one of the commissioners here in deliberations and by Mr. Rigby during testimony, find that the amount of monitoring that is in the draft rules I find to be appropriate and also allows for additional requirements to be imposed on a permit by permit basis. So I do not see a need for adding additional requirements. With respect to local governments and citing decisions and the language about consider versus defer, I would like to keep it as consider. And then I think the last piece is with respect to the drilling engines. I think I am comfortable with where the current language is based on the studies that are in place now and the differing lengths of drilling that occurs with geothermal versus oil and gas development. And I think we also have the ability to impose additional conditions on a permit by permit basis. And so I do not support a change to that at this time. Thanks.
Thank you, Commissioner Oath. Thanks to my fellow commissioners. These are really good deliberative thoughts. Just in general, I want to thank our staff and thank our stakeholders. I'm generally very comfortable that utilizing the Colorado way, we've created a draft that with a few tweaks is appropriate for the state of Colorado. I also echo back to the Colorado Energy Office Director, Will Tour, and his comments and his belief that we are in the right spot with the right balance to create a balanced set of rules that will accommodate the fledgling industry that is geothermal within the state of Colorado. I note from Geothermal Rising the quotations from Governor Polis, and I believe the place that we're getting to is appropriate from the leadership in our administration in terms of where they would like to see things happening in the state of Colorado around deep geothermal. Again, I really, I specifically asked Dr. Jones, who had the information about this, like, where do these rules as drafted with a few tweaks, where do they land in terms of deep geothermal regulation across the states? And he indicated that these would be the most robust protective rules. And he indicated that, I think that the geothermal industry would like them to be a little less robust, a little less protective. I don't think that's where we need to be. I think we're in a good spot. And I think that is good work on the part of all of our stakeholders to help us get to this place. Having said that, I do have sort of the list that we put together, that Ackerman put together. And then each of you touched on a few of the things. What I would like to do is possibly just sort of run through the list and make sure we're all on the same page. Mr. Boudreau, if you could be listening in attentively, what I'm going to want to do after we're done here is probably assign you and staff with a period of time to get back to us with kind of a final clean version. I did look at the calendars, and while I had mentioned we have this set for Thursday, I also note we have this set for Monday the 12th as a set-aside day. And I am perfectly fine as one commissioner to give staff a few more days to sort of get this right. There is some new drafting that at least I know Commissioner Oath wanted to possibly see happen. So an extra day or so, if that would be helpful, we can maybe go to that. So with that said, Commissioner Ackerman, I'm just going to walk through your list as I typed it up, and then let's see where the thumbs end up lying. Deletion of 1321, the special geothermal zone. Is anybody against deleting that? Deleted. Permit time frame, 5 years, and that it must be spud within that time frame is the first question. People comfortable with that? And then Commissioner Cross, we can go into a little further discussion about, the sort of Coyote Trails thing that ended up. All right, so I'm seeing, okay, Commissioner Messner?
Well, just a question, and this may go to the further considerations around the Coyote Trail things, but I'm trying to understand in geothermal world whether spud is whether that'll actually occur or not, or whether operations will just occur. I'm not saying one way is the right or not. I'm just trying to get a better perspective whether that's
I think you're asking
that's going to get used or not.
I think you're asking a really good question to our subject matter expert, Michael Rigby, who I see is on the panel, and perhaps he could visualize himself and provide commissioners with some input around what needs to occur within the 5 years to sort of vest the right of the development. Sorry to put you on the spot, Mr. Rigby.
Sure. So I think, spud is an appropriate term. There's definitely a lot of different things that have to happen maybe prior to spudding that well. That has been indicated by stakeholders. If you are doing, let's say, a power project, you might need to be working out a power purchase agreement, things of that sort. As far as this particular issue of expiration, I think you definitely, a similar kind of consideration is there. You could spud a well and set surface casing in anticipation of further development, if that's kind of where you were leading. But in order to really confirm a resource, you would typically need to drill at least a science well or drill down into the reservoir that you are targeting, gather data such as flow rate data, permeability, different rock characteristics before actually being able to move fully forward. That's why a lot of these first projects are pilot and science wells. I don't know if this is actually helpful or getting to it, but I think the same situations could apply that we've seen before, but there is a lot of exploratory work that still needs to be done in Colorado. So step one for a lot of projects right now is gathering subsurface data from well bores. And that might start as a science well project and then convert into a geothermal well project. It's just going to vary by site, but at the current time, subsurface data is really needed to confirm resources. From there, they can likely set up agreements once they kind of have resources confirmed. But as far as kind of exploration and how they spud, it's a bit different from oil in the fact that the resource really needs confirmed right now rather than infill drilling like we have in the oil and gas industry. I hope that was helpful.
Yeah, no, I mean, I think maybe to keep it simple in this first iteration, we could use the term spud during that 5 years. And then once we start to get a sense of what so like if it's a pilot project, right, then we're going to approve the pilot project, and then they need to undertake that work within the 5 years. If it's a much larger project, well, I just think it's hard to sort of create language that's going to accommodate all of those things. And I wonder, AAG Boudreau, could we say in the language spud or as otherwise determined by the commission at the approval hearing, so that we could accommodate some, I mean, it's always going to be the 5 years, but accommodate a more atypical type project in which this science gets done, then they're good. And I'm just trying to think outside the box.
So I would point out that currently it states if drilling operations have not commenced. So, and as I understand it, in the oil and gas context, that tends to mean any work done in furtherance of getting the drilling done. So that could be something as simple as laying down casing and not necessarily spudding the well. So we can either leave it vague like that, or we can, it sounds like what you're asking is, can you essentially attach a sort of expiration condition to the permit saying you must commence, you
X,
must
Y, and
do
Z by a certain
X
time.
by
Yeah.
5 years? I think we can do that, yeah, and it'll be incumbent upon whether it's the director or the commission approving it
Yeah.
to determine what that sort of trigger date is or trigger event is.
Just as one commissioner, I'm kind of in favor of keeping it with drilling operations and then also inserting or as determined by the director of the commission based upon the particulars of the proposed project. That gives us a little more flexibility, but it does give some certainty to the operator in terms of generally it's 5 years from drilling operations. Other commissioners with thoughts? Commissioner Messmer?
No additional thoughts. I think this is a good idea. I just want to clarify intent. And the intent of the expiration, is it to fully understand or requiring an operator to apply for a permit when they're ready to use the permit, so we don't get into a situation where someone may spud a well or commence drilling operations on year 3 of their 5-year date and then come back and complete it 12 years after that. I mean, is that the intent? Is that my understanding?
Are you asking me, Commissioner Messner?
I think he's asking the world.
Oh, okay, thank you.
Asking the world. That's right.
Sorry to make it about me.
I mean, I think, Commissioner Messner, that is sort of the intent, is we want viability, right, to be established within a certain time frame. And now we're talking 5 years. And again, if we keep it at drilling operations or as otherwise determined by director or the commission, we can have a dialogue with the applicant about, this has A, B, C, and D components. You need to at least have done A and B during that 5-year period in order to then be able to do C and D later, or something like that. I have a feeling we're going to come back to this in this anticipated subsequent rulemaking after we see a few projects and start to get a feel of what they look like and what the characteristics are.
Okay, I'm comfortable with the language you're suggesting, which is, my understanding is drilling operations and or elements determined by the director and commission.
Okay, let's go with that. The Southern Indian Tribe issues, I think everyone was in agreement that as negotiated between Mr. Boudreau and Mr. Ships, we've got good language there, and that DWR is comfortable with that language. Anyone disagree? Reporting mechanisms, Commissioner Ackerman, you noted the issue. You indicated that there's already significant reporting, that you were good with where this is now in terms of the current draft, and perhaps stick that in the study as well. I, at least as one of the commissioner, are comfortable with that approach. What are other folks' thoughts? And if y'all just want to nod up and down, that's good enough. Okay. Next issue was, did we want to go beyond the encouragement of best management practices, including electric and clean rigs to drill and frack? Commissioner Ackerman, you'd indicated that you want to encourage the BMPs, but don't feel there's a need for a mandate there as to certain rigs, at least for now. And we would possibly, look at that as projects start to come in and maybe put that in the SBP. I, again, as one commissioner, am comfortable with that. Others with thoughts? Commissioner Messner?
Yeah, I mean, I'm comfortable with that. I would like to just, I definitely want to include it, I think, as I recommended in the statement of basis and purpose, of utilizing the best technology available. As I would like to encourage that, because I think it makes sense. And I think it's industry practice around the world to utilize something better than tier 2 diesel engines, right? So, so if we can include it in the statement of basis and purpose that we encourage the best technology or utilizing the best technology available, I'm good.
Commissioner Cross?
I'm absolutely fine with putting in the statement of basis of purpose. I do think that it's appropriate for us to encourage it. And as Commissioner Messner said, I think most people do use the technology, and we would expect to see so, as well as I would expect that Ms. Sorensen and others on CDPHE in the consultation process would also try and push for the best equipment possible as well. So I'm good with that inclusion as well.
Okay, agreement there. The next one was with regard to cumulative impacts. The current draft does not go into the detailed cumulative impacts. That is as a result of the way the legislature provided cumulative impacts to us and did not provide it on geothermal. I would note that my perspective is that a lot of the other protective mechanisms are going to not only be protective on a current piece, but will also be useful and used in terms of cumulative impacts as we move forward with the development of geothermal in the state of Colorado. So I don't think we're disregarding this completely. And I'm comfortable with the direction that you provided, Commissioner Ackerman. And I believe we've got consensus here, which is to leave the draft as is. Commissioner Messner?
Yeah, I would agree, leave the draft as is. I want to just emphasize that I do think that elements of cumulative impacts are contemplated in the draft. So it's not like we're ignoring it. I mean, all of our rules as we apply the mitigation hierarchy evaluate and address cumulative impacts to one level or another. And I think particularly the elements of disproportionate impact to communities that are included in the draft, require a showing that an operator has evaluated and addressed cumulative impacts of a number of different things. And so I'm comfortable leaving the draft as it is, but I don't want us to say that I don't want it to get interpreted that we're not addressing the cumulative impact concept, because I think we are. I think it's baked into the rules.
Agreed. Okay, moving forward, the next issue was the concept of extending public comment from 45 days to 60 days in DI communities. Commissioner Ackerman, you indicated support for this. I agree. I think I've heard from the other commissioners, there's agreement on this as well. Next is we had a bunch of testimony and evidence around additional notifications to communities and local governments. And then another issue was around additional consultations, which is different than notifications. And Commissioner Ackerman, my notes reflect you were comfortable with the provision of additional notifications, but didn't necessarily feel a need for additional consultations. Did I get your thoughts right there, Commissioner Ackerman?
You did right. Thanks, Mr. Chair. And just with the addition that, and again, I don't want to beat this horse too hard, but this industry will change over time. I think I also had a note in there that said we can revisit as geothermal does proliferate, and it may be important to extend consultations into other realms that we haven't even thought of yet. But at this point, I don't think we're there yet.
I agree with those thoughts. Does anybody have a different perspective? Commissioner Messner?
I do think we want to be specific about what notifications we're talking about here, because there was a lot of different notifications that were talked about. So I guess I'm not sure the specificity of the notifications that each of you are talking about without a citation of what particular rule that you're indicating. But I'm happy to share the ones that I heard that I think are important. But in particular to the consultations regarding local governments, the rules are not clear. I think as indicated that local governments get a pre-application consultation. It indicates that they can request it, but it's not inherent that the local government has a consultation. And I think for me, that's a mistake. If we want to create an efficient process, if we want to try to encourage efficient permitting at both the state and the local government levels, the coordination between the state and the local government is going to be important. And so I don't know why we wouldn't just require a consultation or pre-application consultation with the relevant local government and then the proximate local government as, if it's within 2,000 feet of the jurisdictional boundary of the proximate local government. To me, that just makes sense. It improves communication. It improves coordination. I don't know why we would limit it.
I don't know that I disagree that. So now we've moved from notification to consultation. So let's finish up on consultation first, and then we can go back to the specifics of notification. So your proposal, Commissioner Messner, is to require consultation with pre-application consultation with the relevant local government and with any proximate local government that's within 2,000 feet of the proposed operation. Is that fair?
Yep, correct.
Okay. Does anybody disagree with that or want to comment on that? Commissioner Ackerman?
Thanks, Mr. Chair. Just a clarification there. I do think this was the intent of the regulations as well, that that the local government had the opportunity to request that consultation and that it would be granted if it was requested, but it does provide some room to not mandatorily involve local governments that may not want a consultation in a consultation prior to moving forward with an application.
Commissioner Cross, did you have anything to add?
No, I believe the way that I read 1303F in combination with 1304A, that consultation would be provided. I think it's appropriate, given that there was some confusion with, as indicated by the ALG, to make sure that that's known. And so I'd be fine with providing some modifications to the language to make sure it's known that local governments will have the opportunity to consult as well on that. So.
And we're not going to mandate consultation with the relevant or proximate local government if they don't want to do it.
Correct.
No, and I agree, but I also think that that local government should opt out versus have to opt in, right? And so I guess that's the difference in the way that I read it, is that they should inherently have the opportunity for a consultation, and then they should have to opt out if they don't want it. The way it reads right now is they have to proactively ask to have a consultation. That doesn't seem right to me.
Mr. Boudreau, are these musings clear as mud to you?
Yes. Adjust 1303 to make it perfectly clear that a pre-application consultation is always warranted with the relevant local government and with the proximate local government if within 2,000 feet of the jurisdictional boundary, but still allow local governments to opt out should they choose to not engage in the pre-application consultation. And yeah, so that's where I understand it to be at the moment.
Everybody good with that? All right, back to notifications. Commissioner Messner, you indicated you might have a more precise list or understanding of the asked for notifications. If you'd like to lead on that, take it away.
Yeah, happy to. Give me a second. I gotta pull it up. All right, so this is what I understand, and if you have other rules, then I'm okay with that too. I just the 4 or 5 rules that I'm hearing need notification are Rule 1302C, 1305D and E, 1308, and 1311. Those are the ones.
I'm good with that. Trust your understanding of the areas in which notifications for additions were asked for. Mr. Boudreau, are you good in terms of moving forward with some edits on those?
Yes, Chair, I believe I am. Just to make sure I have the right list: 1302C, 1305D, 1305E, 1308, and 1311.
Yeah, that's my list. That's Messner's list.
Thanks.
Everybody good? Okay, pooling and pooling percentage. I believe there's, oh, go ahead, Commissioner Messner.
So what was not in my list, but I do think was in Commissioner Oath's list, was a notification associated perhaps with community organizations. And so that was not included in mine. So if that's an addition and a rule citation that you want to add, I don't know if this is the appropriate time to discuss that with Chair Robin.
Yeah, let's go ahead and discuss that. Commissioner Oath, do you want to provide some additional guidance and perspective? I know we had heard from Green Latinos about this. What I heard was it was really important, but I wasn't sure I heard exactly how to draft it. Maybe you've got a better sense of the request and or the place to go.
Well, I had an idea, but actually I think it's the idea I had in 1304D is the wrong place because that's about consultation. And to be clear, I think it's important for it to be about notice. So I'm not sure the right location. We'll ask maybe staff to take a look at right location, but the concept is that that an operator, if the operation is going to be drilling within an RBU, high occupancy building, or a school that is in a disproportionately impacted community, that the operator consult with the community liaison to find out if there is a relevant and active community-based organization, because if so, they're a great resource to help distribute information and notice to community members in that type of a situation.
I think that's a grand concept. Commissioner Cross?
And I just want to for clarification purposes there, you said if it's within 2,000 feet of RBU, HBU, school, et cetera, and a DIC, or is it or a DIC?
And because I think DICs can be a very large geographic area. So I think it's and for in my mind.
Okay, and I agree with that, and I just wanted to double check.
Commissioner Messner?
I think it's a good idea as well. I wonder, operators are required to do a community outreach plan as part of their, if they are siting a facility inside of 2,000 feet of an RBU, I don't know, high occupancy building unit and or a school in a DIC. That could be a place, or I'm not sure, but that's just one thought that I had. So
yeah, that could be part of the plan, is reach out to the community liaison for information about whether or not a community-based organization should be included in the outreach plan. Right. I like that.
Okay. Mr. Boudreau, are you good there?
I had one clarifying question, if that's okay, Mr. Chair.
Please.
When we specify RBU, HOBU, school, and within a DIC, are we saying if you're within 2,000 feet of a residential building unit and that residential building unit is in a DIC, then that triggers the provision we're talking about? Okay. Yeah. So you need both to qualify.
Yes.
Right. Okay. Thank you for that clarity.
Let me dropping back to notifications and those 5 rules that you articulated, and just because I don't have it in front of me and I'm juggling a bunch of different things, but are those notifications to the relevant local government?
Yeah, relevant local government on all of them, I think.
Okay, great. Just wanted to clarify. Again, I don't have the rules up because I've got this Word doc up. Okay, pooling, 45% is where it's at and seems to be comfort level with that from commissioners across the board. And then Commissioner Ackerman, I think you also sort of put that into the study in terms of, you know, after we've done a few of these, does that still make some sense? Is everybody good with that, Commissioner Ackerman?
Yeah, if I could clarify there, Mr. Chair, the portion that I was considering putting in the study wasn't necessarily the percentages, but was more along the lines of equitable compensation with regard to pooling. I think that we don't have enough information really to go forward on that point as well, but I don't know that I would specifically consider percentages in the study, but rather more in line with Commissioner Cross's comments on that.
Okay, no, I appreciate the clarification. My notes were poorly done on that point. Okay, notice to resource owners. I think this has to do with the, well, I think my comments here or my notes here, Commissioner Ackerman, reflect that you were okay with the draft as drafted. Do you want to articulate on that one more time?
Yeah, I can, and I don't think I can give specifics on if the draft is okay there. I heard the allied local governments ask us for better notice to all resource owners and making sure that all resource owners that were included in a DRU would be appropriately notified. I agree that that would be an appropriate practice, and I'm going to have to defer to Mr. Boudreau as to whether or not that's adequately addressed in the regulations.
Mr. Boudreau?
I'm sorry, Commissioner Ackerman, can you repeat the question? I didn't quite follow.
I sure can. Yeah, there was a point brought up by the allied local governments that we want to make sure that there's notification to all resource owners in a DRU that's potentially going to be developed for deep geothermal resources, whether they are consenting or non-consenting, and if they're going to be forced pooled, that all resource owners should be notified.
We're talking about geothermal resource owners, correct?
Yeah.
Correct. Yes, and on this point, yes.
I'm not 100% sure that there is a notification provision, and if so, that might have been a miss on our part. And correct me if I'm missing the issue. But notice to resource owners for you to be, if there's going to be a GRU application submitted. That's what we're talking about, correct?
My Yes, I believe so. So I was just recognizing the allied local government's request there and believe that there should be notification to all resource owners in a DRU. I'm not sure that I know exactly the appropriate point in time to do that.
I think staff and I can figure that out, but I think I understand the request. So if you are filing an application for geothermal resource unit, you must notify everyone to be included within the geothermal resource unit. Thank you for the clarity and sorry for the
No problem.
drawing it out.
The next issue was the issue that some folks had brought up about the fact that currently you can drill and then pool. And the idea from Commissioner Ackerman, and I'm in agreement, is let's get some time to address this. Let's not change it just now, but it ought to be something that we ought to look into. Everybody good with that? Commissioner Messner?
Can't they drill then pool already with oil and gas? Because I'm not sure what the issue is.
They can.
I mean,
So it's
silent, but
yeah. All right. The next issue that identified by Commissioner Ackerman was the undefined cost recovery. But Commissioner Ackerman, if you want to provide us again with your perspective on that, I believe you just wanted to study that too as well.
I sure can, and I don't want to minimize this issue. I appreciate this being brought up by a number of parties. I think it's a very important issue and one that we frankly just don't have a lot of information on, honestly, worldwide at this point. And so while this might be breaking a little new ground and devising some kind of regulatory schema in what cost recovery or equitable compensation might look like, as noted by the parties when they raise this issue, I do think that that's probably something that might be a little beyond the scope of this rulemaking, which is aimed mostly at getting geothermal off the ground in a more pilot phase. But I don't want this issue to slip through the cracks and think that this is an important issue that should be raised as part of the study.
Does anybody have a different opinion? Commissioner Messner?
Just clarification. I mean, Commissioner Ackerman, are you suggesting that that section be deleted from the rules? Because right now it's in the rules. It talks about equitable compensation and has requirements for how that would be handled.
Yeah, thanks for that clarification, Commissioner Messner. That's an important clarification. I am not requesting that it be deleted from the rules, and that currently it stands in the rules so that there needs to be an effort made for equitable compensation currently in all projects. I do think, however, we should further explore what equitable compensation looks like in a more uniform fashion.
Can I ask a question to AAG Boudreau? If that's in the rule, but we sort of have it defined, is there any opportunity for the first few cases to possibly come to commission in which we grapple with that a little bit, see how the operator's doing it, et cetera? And I'm just kind of thinking out of left field here.
I think that's an excellent idea for trying to develop a system that works, especially when we consider that a lot of these applications maybe later down the road will be done almost exclusively administratively. It would certainly help staff to know what factors the commission considers important, and it would also put operators on notice that, based on the first, say, 3 or 4 hearings that went before the commission, these are the factors that the commission wants considered when you're figuring out what is cost recovery or what is equitable compensation. And I think I used the phrase earlier, build a body of case law, but I think that really does help staff figure out exactly what the commission expects when trying to apply the rules.
If others are okay with it, with that idea in mind, maybe we could put some language in the SBP to that regard. All right. There was an identification by Commissioner Ackerman from some of the local governments to exempt a non-consensual, exempt from pooling a local government that has not consented to pooling. And I agree with Commissioner Ackerman that we do not need to go there at this time. Others okay with that direction? So that's not a change. It's just we're identifying issues. And there were a few cleanups around working pad typo, et cetera. I assume, Mr. Boudreau, you'll catch those as you and staff go through this final iteration.
Yes, and with permission from the commission, I might try to reach out to Ms. Kate Burke, who brought up some of the comments about geothermal pad surface.
Excellent idea. Kate is the one who caught the typos and cleanups, so that would be great. The next issue that was identified is the conversion of wellbore issue. Commissioner Ackerman, do you want to restate your position on that?
Yeah, I'll restate and actually just add a little more clarification. I'm not sure that a full 2G is the best approach, but I'm also not sure that a Form 2 is the right approach either. And I think I agree with a lot of the testimony that was given that some proper notification and opportunities for participation in a full well conversion is appropriate. And whether we do that through a 2G or a Form 2 with some amended requirements, I'm in favor of not just a purely administrative action with no opportunities for input from the local government or from affected people if we're talking about a full conversion of use. Is that clear as mud?
That's fair. That's fair. And I think one of the things that we heard from the local governments was true is that Form 2s don't get noticed to local governments, and they don't want to have to be, micromanaging Form 2 submittals. I think we could twist our rule here that for a Form 2 that contemplates a conversion of well to geothermal, there ought to be notice to the relevant and local government and proximate local government that's within 2,000 feet. In other words, we could twist the Form 2 just a little bit and say it's a Form 2 with notice.
That definitely conforms with my thoughts, Mr. Chair.
Commissioner Messner?
Appreciate the thoughts of both of you. I also think it could be the other way, because there's already a provision in the rules, and I was just trying to look it up now, and I didn't have time to look it up. But since Mr. Boudreau wrote the rules, he knows it by heart. But it does allow for, in a Form 2G, for an operator to not submit inapplicable portions of that 2G. And so if you want to keep it, in my opinion, the cleanest, that already has notification considerations, you can require that 2G, certain plans, depending on what that repurposing technology is being proposed to utilize, right? Because a repurposed well for uses like was presented by Geothermal Rising, and I can't remember the company name, but are pretty low impact versus someone who's choosing to repurpose it to and for an enhanced geothermal system that may require additional completion activities. And so understanding there's differences in technology and differences in perhaps plan submittals as part of a 2G, requiring a 2G submittal, but allowing the operator and the director and staff to determine what appropriate plans should be submitted as part of that, so that the evaluation of avoiding adverse impacts can be done both by the local government and ECMC. Form 2 doesn't necessarily allow the commission to evaluate adverse impacts.
Others with thoughts? Do we want to assign this to staff to possibly draft in the alternative, and then we could take a look at both? I don't know. What direction do we want to give here?
I mean, I'm okay with having staff take a crack at it. I mean, I think they've already taken a crack at it. They're suggesting a Form 2, but I do think it's important that whatever's being submitted in a conversion for an oil well to a deep geothermal well have enough information provided that we can make a determination whether it's protected or not. And so that's not necessarily information that's inherently provided in a Form 2. So some modification of that seems important.
Commissioner Ackerman?
Yeah, I mean, I think we're all kind of dancing around the same tree here, honestly, but I think in the end, we certainly are interested in protection. I would just note that as part of the application process, it's you know, there are protective components that are evaluated by staff in their acceptance of that Form 2. And so I think, Mr. Chair, maybe a good way to do it would be hopefully staff's got enough of our kind of thought here that they could take a crack at making sure that they're including, to the extent possible, our comments and Commissioner Messner's thoughts. And I'm not sure what the best mechanism for application would be.
All right, Mr. Boudreau, we're going to punt to you, Mr. Rigby, and the rest of your team. We'll look forward to seeing what sort of football you bring back to us on Monday. All right. There was an identification that some of the parties wanted 507 parties in particular to be able to request hearing. Commissioner Ackerman's direction on this, and I agree with it, was at this point, I would leave this to director discretion, and we might want to be looking at this after we've had a few more of these deep geothermal applications come through. Everybody good with that? Commissioner Oath?
I agree with leaving the regulation as is with director discretion. I think my thought and curious for reactions to this was adding some statement of basis and purpose language, asking the director to come back kind of annually to
Yes.
us information about what types of applications have been dealt with and those types of things, so we can kind of track that and figure out together when the right time is to add that to the rules.
Friendly amendment to your SBP. Could we, at the beginning, have it every 6 months, the director come back and report to us?
Yep, sure.
Okay. Mr. Boudreau, you are so directed to draft along those lines. The next addition or issue identification was one party, 350 Colorado, wanted a commitment to a second rulemaking. I believe all 5 of us have agreed that the rulemakings need to be iterative, that we will likely have additional rulemakings, that they'll be informed by permits that are processed ahead of those rulemakings, but that we don't really want to constrain ourselves to a specific time frame or a specific issue for rulemaking. We'll take a look at that and make sure that our rules remain protective and not stale. If you could accommodate that in a sentence or so in the SBP, Mr. Boudreau, I think that would be great. All right, next, it seemed like there was agreement that we don't need a 2,000-foot setback, at least for now. There was also direction from commissioners that local governments who raise that issue continue to have the authority to put setbacks in their local regulations. And then there was also recognition of the Western and rural local government and other communities that might not want such a setback. So for now, we would not have a setback of 2,000 feet. Commissioner Messner?
Thanks. I mean, I agree with this. It's the position that I took. I think it's really important, and I know that staff was going to do this anyway, but I think the reasons why need to be captured clearly in the statement of basis and purpose. And for me, there are instances, in particular with this energy source, that being proximate to residential units could be beneficial, particularly for direct use and other things. And so I just would like to make sure that we're beefing out the statement of basis and purpose to make sure that it's clear why something less than 2,000 feet in this particular energy technology we feel both is protective but also potentially beneficial.
I think we're all good with that. AG Boudreau, a little more massaging of the SBP along those lines would be appreciated. All right. The next issue identified in Commissioner Ackerman's list I'm gonna read what I wrote down, and I'm gonna ask Commissioner Ackerman to elaborate. Community and cumulative impacts through notice and educational materials requested. I have no idea what that means.
Yeah, I might have had a mistype in my notes, so misstatement as well. But the request from 350 Colorado was to help protect the community and reduce impacts by, and I might have put cumulative impacts by mistake, by ensuring the proper notice, which we've already addressed, and then the production and dissemination of educational materials on geothermal. I'm a little iffy, Mr. Chair, on how or if we should work that into the regulations, or rather just include that as a best management practice to ensure that we're just disseminating educational materials that are targeted project by project, but also releasing educational materials on this bold step forward in geothermal in Colorado in general. So that a word soup a little bit, but
yeah, I mean, I think we could generate some language in the SBP that these are, appropriate and good ideas. It's not mandatory, but I mean, the operators that testified or the trade group that testified said that that's going to be part of their best practices and they're going to do it. So I think that is a good starting place for us. If it turns out that's not happening as we come back to this at some time in the future, we could revisit. Commissioner Oath?
I think that could be fine. I think the right balance here is to encourage it, not a requirement. And I could get my arms around being fine with it just being in the statement of basis and purpose. But one additional option would be in the community outreach plan provision to say, we encourage that part of that plan include dissemination of education materials.
I like that. I think that's a value add. Okay, nodding of heads up and down fashion. Moving on, leakage was an issue that was brought about, Commissioner Ackerman, and your comment was something along the lines that our wellbore integrity rules deal with it. It is already addressed through the rest of our underground rules, and there's not a need to do something further with this at this point in time. I would agree with that, if assuming I got what you were saying accurately.
you sure did, and I would just add to that, Mr. Chair, that we also have rules in place for the shutting in, the repair, the protection of aquifers, and numerous other rules associated with the protection of leakage.
Okay. Next issue identified is the issue of.
Can we pause for just a second there?
Oh yeah,
on that,
go ahead. Sorry.
And I think that kind of related to that is also the aspect. I know 350 Colorado was hoping to, and I'm just trying to pull up this section now. Also hoping to get clarification on the conversion aspect. I'm just trying to find it now. And I apologize. So I believe the way it's written now is the operator will demonstrate wellbore integrity for converted wells with appropriate logging and or mechanical testing as approved, and that's 1311 F2. Does it make sense? One of the concerns 350 Colorado had, does it make sense to, instead of saying as approved by the director, to say consistent, or like that we're going to use our 417 through 420 rules with respect to mechanical integrity and braid head testing for clarification purposes, just so it doesn't sound like there's an alternative approval for what integrity testing may be required there?
Sorry, I was taking notes. I didn't pay attention to the question. Do others want to weigh in? Commissioner Ackerman?
It's a good point raised by Commissioner Cross, and I think this might be, at your discretion, Mr. Chair, a good thing for Mr. Rigby to comment on. We might be able to add a little bit to this conversation.
Mr. Rigby.
Hi, so as we have it written now, 417 does apply to all geothermal wells. It's not explicitly listed in the conversion rule. If you all think explicitly listing in a conversion rule, it would be helpful. That could be something to explore. But 417 is applicable and incorporated by reference for active operating geothermal wells.
Commissioner Cross?
Again, I believe my reading of it, I understood it to include our 417 mechanical integrity testing rules. I just wanted to raise the point because it was raised by 350 Colorado that it didn't seem clear. And so instead of using as required by Rule 417 and the conversion aspect just specifically, I just figured I'd at least raise that point to see if other commissioners thought appropriate to reference 417 there, whether they also understood it to be clear. If nothing else, I think it's important to note in the SBP that this is what's intended. And I will just say one additional point. I know that, and again, I raised this in my deliberative comments at first, I know that 350 Colorado referenced Pennsylvania doing more mechanical integrity testing than we do in Colorado. I don't think that's necessary, especially given our more robust well-bore integrity rules that we have, and I do believe the testing we have now is sufficient. So I don't know that we need to go that far, but I would be interested to see if it makes more sense for everyone to mention 417 and 1311 F2 or not.
Everybody good with that? All right, nodding of heads in the up and down fashion. Mr. Boudreau, are you good?
So we are adjusting 1311 F2 to specifically reference MIT standards set out in Rule 417. Is that correct?
I believe that's correct.
Thank you.
All right. The next issue, I think, is the movement away from the word defer and move to the word consider when it comes to the local government permitting process. I was pretty straightforward with the local governments that raised this issue on 2 points. Point number one is we've done, I think, a stellar job of establishing intercoordinated working relationships with all the local governments across the state, and that's no easy task. I believe that the work we do with the local governments is a quote consider work and not a defer work. To the extent that the mission change rules use the word defer, I think that is not an accurate understanding of how we work with local governments. Moving to consider, I believe, is a better reflection of the work we're doing. And I don't move to consider in a manner to try to adjust the working relationships we have with all of our local governments. I believe it's important to move to that because that is indeed appropriate understanding of our interrelationships with local governments. This is a matter that is also being briefed in the cumulative impacts rulemaking. Staff has suggested the word consider there as well. So this is consistent with the approach that we're looking at there. Does anyone have other thoughts on this issue? All right, seeing none. The last issue was mineral owner notice, but I don't have anything other than that written down, Commissioner Ackerman. We may have even already covered it. I'm not sure.
Thanks, Mr. Chair. I don't think we quite did. Mr. Boudreau will have to help me if we do cover this somewhere in the regulations that I'm not aware of. But the Kogan API group in their testimony talked about how geothermal companies may not be aware of other minerals operations taking place in any given area in which they might explore, and that they should, if they're intending to explore, give notice to owners of other minerals within that jurisdiction. Now that said, I also qualified that by saying I'm not sure what that mechanism would look like. I don't know, how we currently handle that, and maybe staff can help us out a little bit with that. But I do think that merits some exploration.
Mr. Boudreau?
Thank you. Oh, sorry, go ahead.
No, go ahead.
So to answer Commissioner Ackerman's question, no, the current draft does not include notice to owners of other minerals, which I understand to mean at this point in time, oil and gas owners. So yeah, it's not in there, and happy to include something in the draft if that's the commission's direction. And kind of as Commissioner Ackerman alluded to, maybe some direction on what that notice might look like could help.
Commissioner Messner?
So I'm going to ask a question. It's going to be a stupid question, but I think I just need to better understand it. When we talk about mineral ownership in relation to geothermal versus oil and gas, where we better understand the geologic formations that hold oil and gas, and so have a better understanding of potential mineral ownership. And particularly in the case of notice, in a situation where there may or may not be enough information developed subsurface to fully understand the potential mineral ownership. I'm just trying to figure out how this works. So though maybe I'm not understanding the technical aspects here. So maybe someone can help me.
Commissioner Ackerman?
And I can't answer that, but I can add to it that what really piqued my interest with regard to this suggestion was safety more than anything else. You know, our geothermal explorers plugged into what existing oil and gas infrastructure might look like in the area, and if not, how do they get plugged in? Contacting of mineral owners and other oil and gas explorers, I think, is a pretty direct way to do that. But that was my general interest in this comment.
Okay.
Do we have direction then?
If I were staff, I would say no. But I do think, yeah, at least from this commissioner's perspective, just one person's perspective, I do think it's important that if they're not already required to do so, it's important for geothermal explorers to be plugged into infrastructure in the area, particularly oil and gas infrastructure that could cause some problems with intersections. And maybe Mr. Rigby can help us.
Mr. Rigby?
Yes, thanks. I just wanted to add the clarifying point that any geothermal resource unit would include a geothermal area unit kind of plan review that would include reviewing all wells within the unit area and within a quarter mile of the units. So that is one mechanism that would relate to this, but it does not include any sort of notice to a mineral owner.
Am I recollecting that this was an issue that geothermal was thinking about, and then COGA provided some language? And did we get confirmation as to whether that could be workable? Does anybody recall?
I don't recall geothermal raising this issue. I just have in my notes that it was a COGA point, and don't mean to shortchange that point, Mr. Chair, but a question to Mr. Rigby would be, Mr. Rigby, when another oil and gas company begins to explore in an area where existing oil and gas companies are they required to notify all minerals owners under current regulations?
Mr. Rigby?
I would need to check on that point. They are required similarly for sure to evaluate all wells in the area and other units in the area and how their unit will interact with those existing operations. That said, I would have to double check on notice requirements. I am unsure on that topic. Unsure if Ben would have a further idea there.
This is just based on my memory of what went on during party presentations. I seem to remember geothermal industry was opposed because they felt like that would create a burdensome standard that would basically include requiring title opinions. for mineral resources. But that's just based on my memory, and I hate to speak for someone else, and I think that's the question we're trying to address, isn't it?
Yeah, thank you, Mr. Chair, sorry.
Go ahead.
Thank you, Mr. Boudreau, and I think you hit right on the the second issue there that caused me concern is I don't want it to be an extensive, difficult procedure that we don't require on any other front at this point. And so I think I would, Mr. Chair, amend to be a little more clear in my request here is that geothermal operators are required to follow the same requirements that additional minerals, oil and gas explorers are required to follow. And it sounds like to me from Mr. Rigby that would be the submission and evaluation of a minerals plan, but not necessarily individual notice to every single minerals owner.
Given that this is beyond my pay grade at least, and we're struggling with it, I am somewhat inclined to bring back geothermal rising and Mr. Lepore to opine on this, but I don't want to do that if that creates consternation with my fellow commissioners. Commissioner Messner?
I mean, I understand what Commissioner Ackerman's trying to accomplish here, and I think there's a difference between mineral owners and mineral operators. And I mean, essentially, I think Commissioner Ackerman, you're talking about like 811, notification, come mark and locate before you dig. And I think that makes sense. I'm sure that there's some element in the existing oil and gas rules that require that. And I mean, it makes sense, but I would focus this on mineral operators, not mineral owners. And I think maybe it accomplishes the same thing. But I would just defer it to staff to understand the intent of what's being discussed here and have them, develop that into something that maybe works well in the rules.
So why don't we do this? Let's give vague direction to staff and allow staff, as you're going to do the same with one of the other pieces, you're going to reach out to a party. Feel free to reach out to the relevant parties on this topic and come back to us with something that accomplishes the goal that is also workable. All right, the last issue was the issue Commissioner Cross brought back to the list, which was the Rule 211 issue. And I believe there's consensus across the board that we would go with the language that was agreed upon between Mr. Sura and Mr. Lepore. Is everybody good with that, Commissioner Messner?
Unless I'm missing something, I'm not sure Mr. Sura and Mr. Lepore agreed on language. I think you had Mr. Sura indicating that he thought that the language that he provided captured everything that Mr. Lepore was trying to say and preserved existing Rule 211 hearing applications in process right now. So I'm not sure there was consensus there, although Mr. Lepore and Mr. Sura could tell me different, but that's not what I heard.
I was trying to end this on a kumbaya moment, and you just destroyed it there, Commissioner Messner.
I mean, so my opinion on this matter is that Mr. Sura's language does capture exactly what Mr. Lepore is trying to accomplish. So, and still preserves, Rule 211 hearing requests for hearing in the pipeline that local governments have already submitted. And so, to me, it makes sense just to adopt the language that Mr. Sura had proposed, and not, which then doesn't mess with all the discussions that we had in developing that Rule 211, which I thought was a very important part of previous rulemakings. And I'm not even sure it's appropriate for a geothermal rulemaking to modify an oil and gas rule without it being clear as to the intent there. And so I think it's important to preserve the Rule 211 process in a geothermal rulemaking, but that's just my thought. So someone can tell me differently if they heard it different than I did.
All right, I'm inclined to have hearings manager Smeltz bring the two lawyers back to the table so that we can totally understand who agreed with who on the topic. I mean, so let's go ahead and do that. And then while we do that, is there anything else that was on anyone's list that I missed? Commissioner Ackerman?
Yeah, thanks, Mr. Chair. You know, I'd have to go back and listen to my own testimony to see whether it was I that missed these originally or whether we missed them in the review. But I don't think I heard in our review addressing whether we should apply cumulative impacts to geothermal. And I don't think in our review we touched base on involving the community liaisons in geothermal. And someone can correct me if I'm wrong there.
And what are your opinions on the first topic?
My opinions on both of them. So I'll start with the community liaison was, you know, and I'll expand on a little bit on my earlier thoughts. And that's that we don't at this time include the community liaison in geothermal projects. Again, I think geothermal projects at the initiation are going to be exploratory in nature and not really what we'll generally see in communities in the future. That said, we're also just getting community liaisons up to speed on oil and gas, and I think their focus is best spent there. And so for those reasons, I did not advocate for including the community liaison. Nonetheless, I don't feel very, very strongly about that, as I do feel like more outreach is generally better. And I'm just trying to strike a balance and hit the points as finely as I can as we strike out on these original rules. The other was cumulative impacts application to geothermal. And my statement was that we were not directed to do so by the legislature at a time when cumulative impacts was a prominent point of discussion. And I don't think that it's prudent to do so at this point. Once again, these are largely one-off exploratory projects and are not commercialization of the technology yet, which won't be a significant contributor to cumulative impacts. And so I think at this time, it's not necessary to add them to the cumulative impacts analysis based on those 2 points, but perhaps sometime in the future we'll reach that point.
Commissioner Oath?
Thank you. On the first point, I think I would just want to make sure that we're clear that when you're saying, Commissioner Ackerman, that you're not in favor of incorporating community liaisons in this process, that's leaving in place what we talked about earlier in the sense of requiring operators to consult with the community liaison, and if they're in a disproportionately impacted community and within 2,000 feet of RBUs, et cetera.
I might need some clarification on the clarification there, Commissioner Oath. My understanding is that we were not mandatorily requiring connection with the community liaison with regard to geothermal.
Okay.
And maybe Mr. Boudreau can help me there if I'm off base.
Thank you, commissioners. First, can you hear me? Because my AirPods
Yes.
stopped. Okay. So what I have on community liaisons is regarding additional notifications, but not consultation, notifications for community organizations. If the operation is within 2,000 feet of a residential building unit, high occupancy building unit, or school or child care center, and that facility is also within a DI community, the operator will consult with the community liaison to find out if there are any relevant community organizations, because the community liaisons are the community organizations are good resources for distributing the information needed to the community. And I think that's the only direction we currently have on how to use community liaisons within the oil and gas, the deep geothermal rules.
And thank you. And I would just add that we talked about that being added to the community outreach plan provisions. That's where that would be located.
That's right.
And I'm on board with that as well. Thank you for the clarifications.
Great. And then I think with respect to the second piece on cumulative impact analyses, that what I remember of the discussion on that was Commissioner Messner stressing the fact that it's not that we are not addressing cumulative impacts in many other ways, and the importance of acknowledging that throughout this process.
All right, are we good on those topics, Commissioner Messner?
Yeah, I do want to make a little clarification on the community liaison piece. I mean, here we clearly have the utilization of it in the community outreach plan, you know, as a requirement in the rules. Well, I guess I don't know why we wouldn't just have the community liaison available as necessary to better aid in communication and coordination in the process. If we're already using them for one element, I don't know where else they would necessarily apply in these particular rules, but are we trying to limit them to for some particular reason?
Commissioner Ackerman?
Yeah, it's a fair question, Commissioner Messner. And again, I was just trying to put as fine a point on the moving forward of these regulations as possible. I'm not necessarily opposed to community liaisons being engaged as we've discussed here today. My thought process was just along the lines of we haven't even really clearly defined what the community liaisons will be doing entirely in their job. And you know, the thought of me was to get them engaged in their intended purpose of oil and gas development, not necessarily that I think that it's necessary to exclude them from other forms of community engagement in the future. So I'm a little bit on the tip of the razor here and not necessarily willing to take a stand on either side of this argument. A further stand, at least.
Commissioner Oath?
I would say, from my perspective, I'm comfortable with the starting point that we have of utilizing the community liaison in the outreach plan to help identify whether there are community-based organizations. I'm sensitive to the fact that it's a new position. I think the priority for their work ought to be the scope of work, you know, that they were kind of initially brought on board for, and not knowing how much additional capacity they may have, I'd be reluctant to add additional duties to their work at this time.
So are we comfortable that this is something we should put some language in the SBP around? I mean, you know, a fundamental point right now is we don't have the community liaisons yet. We don't have the community liaison manager at this point because we're in the process of hiring for that. The cumulative impacts rulemaking is going to further define, and we don't know what that's going to look like, what the community liaison is, what they're going to do, what sort of capacity they have to be able to do all of this. I think it's a great notion. It might be a little bit premature to fully flesh it out, but like we could put in the SBP that we truly think community liaison work here is a good idea. I don't know. Commissioner Messner?
So, I mean, I'm gonna agree with Commissioner Oath. I mean, I'm okay with not broadly utilizing a community liaison, but we already made a decision earlier that we're prescribing the utilization of the community liaison in the community outreach plan. So I'm okay leaving it in there in the rules. And then if you want to put it in the statement of basis and purpose that it gets utilized in geothermal applications as necessary, that's fine. I was just asking the question why we were limiting it. And I think Commissioner Oath made good argument as to why we're limiting it capacity. So that's, I guess, my thoughts.
I think I would encourage AAG Boudreaux to put in the SBP some notation that the community use of community liaison is to be taken into account based upon, the other duties that they were assigned via the statute, because that was kind of their primary, and I don't know, something like that, so that we're not unduly circumscribing our community liaisons or unduly providing them with so much that they have to do that they're going to fail before they get hired. Take a stab at that, AAG Boudreaux, and bring it back to us and we'll take a look.
I'll be happy to. Thank you.
All right, we still got our 211 issue. I've got the two lawyers teed up here. So why don't we elevate both of them? you guys thought you were done and you went and changed shirts and you're no longer professional. How dare you? We still working hard here, although I did change the shirt to a Hawaiian shirt to make myself happy too. All right, Mr. Lepore, you're recognized on the issue.
Thank you, Mr. Chairman. Apologize for my casual appearance. I promise you my wrist is sore from taking notes carefully. I thought that Mr. Sura had said that he agreed that our language, my language, that he would accept that. He said he liked his better. There's a reason I like mine better. Maybe they get us to the same place. But from our perspective, it's important that it is explicit, not implicit, that the wells have to have been low producing or inactive for 3 years prior to the effective date of these rules. Then there's 1 more year before which the local government could make the request to P&A for lack of being used or useful, and the operator could not assert future use as geothermal. One last point I want to make is I don't see how this affects the existing 211, as some commissioners have suggested. This is all in Rule 1320. It is a separate 1320C rule. Parts of it cross-reference 211 and 503G12B, but this subpart 2 does not. This subpart 2 is specific to conversion of an existing oil and gas well that has been inactive or low producing for 3 years to a geothermal well.
Okay, thank you for reappearing before us. Mr. Sura, you're recognized for comments on this topic.
Sure, thank you. So the relevant provision is in 503G12. 503G12 is how you bring 211 hearing to the commission, and that very clearly requires a certification that the well has been low producing each year of the previous 3 years. So the language that, I mean, we've got 2 attorneys and a bunch of really smart people on this call. I mean, I'd like you to just read which one reads better and makes more sense. I find the other one confusing. I think that it is trying to accomplish the same thing, but by reiterating the requirements of the active provision, I just don't think that I think it's confusing.
Okay, fair enough. You're both excused unless folks have questions. Commissioner or AG Boudreau?
Yes, thank you. So regardless of which way the commission goes, I have Mr. Sura's proposed language, and I remember Mr. Lepore bringing it up on the screen, but I don't have it written down somewhere. If Mr. Lepore would mind emailing that to me, just so that whichever way the commission goes, I'll have both of them available.
I'm happy to email it to you, Mr. Boudreau.
Thank you.
Thank you, Mr. Lepore. Commissioners, further thoughts on this issue? Commissioner Cross?
Thank you, Mr. Chair. I think I agree that both sets of language get to the same place. I think, in my opinion, one, I guess this is what lawyers get paid for, is to try and create some ambiguity here. And given that there is at least some ambiguity and some differences in this, I tend to think that it's probably better that we have the reiteration. I know Mr. Sura said that it seemed a little confusing to have that reiteration in there, but to avoid any kind of ambiguity, I'd be in favor of including the language that Mr. Lepore added to it to avoid future problems down the road.
I appreciate that. I think I'm 51% in favor of that as well. and would suggest maybe we try this out, and when we come back for our future rulemaking, we can see whether this is being abused or not. Other commissioners with thoughts? Commissioner Messner?
Yeah, I'm gonna need Mr. Lepore's language before I can make a determination on that. The way I read it, and I've only read it on the screen for a short amount of time. It seemed the ambiguity in there seemed to be whether existing 211 permits were preserved or not. So, right, I'm happy to punt this and make the decision on Monday if you want to do that. But
Yeah,
without having the language in front of me, I don't know.
Let's just do that. Mr. Boudreau, put into the draft the alternative with both languages. I would note for the record, we've had 211 in effect since 2021, and we've never had a hearing. So we may be debating something that is fairly nuanced in terms of how often it's going to happen. But let's put both sets of language in the draft. And with that, I do believe we perhaps have tackled all the outstanding issues. Looking to my fellow commissioners if there are any other issues, and also to Mr. Boudreau if he has identified any issues that we've not tackled.
Just a clarifying question. I believe we addressed drilling engines, right? We're comfortable. I think that had to do with electric drilling.
Yeah, and that's just going to be SBP language that we want to see BMPs around it, but not as actual substantive requirement.
Okay,
at
thank
this
you. That was my
stage. All right. Mr. Boudreau, I had earlier suggested that we've got 2 dates set aside for finalizing this rulemaking. 2 days from now, this Thursday or Monday, the 12th. I'm fine and would be fine to give you and staff until the 12th, because there's, a significant amount of work that needs to be done. The other thing is we could continue this to some other day later next week. That is within our prerogative as well. Do you have some perspective on timing?
Yeah, I think staff feel like Monday would be an appropriate time. It would give us time to get through all of this, and then give us time to reread everything, and then still get it back to the commission without having to reschedule anything.
Okay, and do you think you can get a draft back to commissioners ahead of the weekend?
Yes, I
Perhaps
think
we
we
could-
could definitely get something by close of business on Friday the 9th.
Okay. Mr. Surratt, acknowledge that you visualized. Is that purposeful?
Yes, it is. And just to clarify, in rereading it, it doesn't do what you think it does, and doesn't do what it's purported to do. The language actually requires that any Rule 211 application has to have been low producing for 3 years prior to this effective date, and then continues to be low producing for a year thereafter. It affects, the way that I read it, any application, even 20 years from now, is going to have to have been low producing 3 years prior to the effective date. I just don't, again, I think that the intent was that it was going to do what the language that I proposed does, but I don't think it gets there.
Okay, thank you for that last piece of information. Mr. Lepore, you're recognized for 30 seconds.
I think the best thing to do at this point is drop this and go with the rules that were drafted. That's staff recommended. Leave it at that. If you go backwards, you're applying this retroactively. You are taking away notice from operators. You're taking away notice from existing oil and gas owners, and you're taking away opportunity from future geothermal drillers. So stick with what you've got.
All right, thank you both for bearing with. Commissioners, seeing nothing further, we should be getting a draft from staff sometime before close of business Friday. Would encourage everybody to take a teensy part of your weekend to go through that. And with that, I think we are looking for a motion to continue this matter until August 12th at 9 a.m.
So moved.
Second.
Motion and a second. Further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. For those of you who are interested in ECMC work, we've got a business agenda tomorrow morning. For those of you who want to talk with us or hear us discuss deep geothermal, that'll take place Monday morning, August 12th at 9 a.m. Thank you very much. Appreciate all the hard work.